Lordship, I beg to mention for one motion matter, my lord. Petitioner's husband and other three members were detained by the on 25/5/2025 and detained at Walpara detention camp. But the family members not allowed to audience and obtains any necessary signature on the wakalatnama and other documents.
Can we take it up on Monday?
May I please, Your Lordship? First, I beg to mention item number 14 with concern of others at Your Lordship. 14, motion matter. Lordship, this matter may be adjourned for the day.
14. Okay, also for the day is free for violent counsel for the petition.
I'm so blessed.
May it pleases your lordship. Lordship, I beg to mention item number 29 in the supplementary motion, lordship. There are some inadvertent mistakes in the pleadings, lordship. I want to withdraw that writ petition and with the liberty to file afresh.
Okay.
And I have taken the consent of the other side.
Okay. All sides are represented. Mrs. D. Ghosh, learned counsel for the petitioner, submits that there are some mistakes in the writ petition, and therefore she prays for liberty to withdraw the writ petition. You have to withdraw the writ petition with liberty to approach the court again. Most of the prayer is allowed. Matter is dismissed on withdrawal with liberty to approach again.
Deeply obliged.
May it please, Your Lordship. My Lord, I pray for listing of a fresh writ appeal on 18th of June, man. Wednesday.
Okay.
I'm obliged.
29.
Item 1 আছে।
Item 1 for motion.
Please, your lordship, my lord, ex parte order, my lord, passed by the Foreigners Tribunal, Morigaon, my lord, dated 7/1/2023, my lord. My lord, the petitioner before her lordship, my lord, she received notice, is a fact, my lord, but she received notice on notice was issued on 25/2/2020, directing her to appear before the court on 21/3/2020, my lord. Thereafter, my lord, due to COVID, she could not appear. Thereafter, my lord, she appeared with her engaged counsel, my lord. And she prayed time for filing WS. So, my lord, she could not file WS right from, my lord, 21/2001 to 26/3/2001. Thereafter, my lord, she could not appear before the court below, my lord. She is a gynecologist patient and she was suffering at that relevant time, COVID also, my lord. And her engaged lawyer, my lord, had told her he will inform her whenever the occasion arises. But thereafter, my lord, she came to know that the
I don't know, when I was in your side, I had never found any such lawyer who was so benevolent. When I was there, I never found a lawyer.
My lord, I mentioned the name of lawyer also, Mohammed Mujibur Rahman, my lord. But so far, I could know, my lord, he is now under suspension, my lord. He is a very cunning, although he is an advocate. So, my lord, they let her face trial, my lord. She could not submit even WS also, my lord.
But you had sufficient time for 2 years.
My lord.
2003, at 2023, the ex parte opinion was passed. What is your explanation for non-appearance?
Non-appearance, my lord, the order is, my lord, next are A, page 13. There is an order 7/1/23. She could not appear from 5/5/2021 till the date of passing the order. Paragraph 2, my lord, page 14. Bill number 2, on 21/3/2020, the opposite party did not appear before the tribunal. Thereafter, due to COVID and prevailing lockdown, the court functioning was remained closed. Subsequently, after commencement of the court functioning, the opposite party had filed petition seeking adjournment from 2021 to 26/3/2021. Subsequently, neither the opposite party nor her engaged advocate appeared before the tribunal to take any steps on the date fixed from 5/5/2021 till today. So considering that
2
aspect,
years, Lordship, no.
No, not only that. You please come to page 16.
16.
Yes, page 16. You got the certified copy in 2018. So there's no justification. Your explanation is not acceptable. Next, page 18, your certified copy is obtained in 2018.
Page 18.
Third certified copy at page 20 is again 2018.
These are my lot voter list.
Correct, but it's a certified copy. You have, if you took the certified copy in 2018.
Somebody has
So
taken.
therefore, somebody,
Somebody has taken this copy method.
now I understand. There are many people, benevolent people who go on from office to office correcting certified copies. Many benevolent people are around.
Let her face trial, my lord.
Lordship, considerable delay also and references of 2010, Lordship.
And you went to a very interesting doctor.
18 means before 20, my lord.
He is a gynecologist and he is diagnosing mental, what you call, gradual decline in memory. We understand, but the gynecologist is interesting. We must know him. The same thing here. Many learned counsel make their argument and go away, and then I don't remember what what was argued at times. See, if I can go to this gynecologist, have my mental examination done, it would be wonderful. I'm sorry, Mrs. Devi, you can't dismiss it.
Lordship issued order with my cost, my lord. Even my lord, the cost may be in.
No,
my lord.
this ground is not acceptable. When you have certified copies in 2018, it's
That is before COVID, my lord.
correct.
So documents were there, Lordship. She had all the time to produce the documents
it.
before the
No,
court, Lordship.
can't be permissible.
Sufficient opportunities were granted to the petitioner to face her case, Lordship, before
My
the
lord, let me
trial
give
court.
some time, my lord. I will produce your lordship, my lord, in similar case. my lord.
Pardon me?
Let me give some time, my lord. I will produce your lordship in similar case, lordship issued order with cost, my lord. So let her face trial. So I may be allowed some time, my lord.
Okay, list after a week as prayed for by Mrs. B. Devi and counsel for the petitioner.
After a week.
So some copy. এটা বনাই ল'ব না।
Item 2 for motion.
May I please, your lordship? My lord, but this PIL has been filed, my lord, for the ground of illegality committed by the Research Training College, Virja. While there, when this NCTE recognition was withdrawn, and illegally that was sold as a matter the having the NCTE recognition in the website of the Guwahati University for the two occasions. That is for the 2022 again in 2024.
Who are you?
My lord, I am, my lord, one of the, my lord, Education Foundation, my lord. It is, my lord, annexer one of my,
PIL would not be maintainable. It would be your personal interest involved.
how, my lord?
If you are one of the founder, it's your personal interest. It can't
No,
be a
my lord,
public interest.
I am, my lord, founder of a education foundation, my lord. But I am interest for the students who are basically from the poor and rural area, my lord. I am always giving counseling for their to right source of their education institution. Basically, my lord, in the B.Ed and B.Ed course, because I am in the my lord, DLEd, my lord. So in that aspect, my lord, whenever I was searching the website, that was found that the my lord, NCTE, my lord, in March earlier, that was my lord, their recognition of the college concern was withdrawn. But as per the Supreme Court order, it is, that is decided in 2012, my lord, in that specifically mentioned that if the recognition is withdrawn, no college can be affiliated under any university and no course can be provided. So this is a clear violation, and that was also communicated to the Guwahati University. But everything was done because of the respondent number 4 and 9, because 9 is holding the post of the 4, and he is
Can
the
you get us information by Monday, Mr. Fukan,
Milord.
about affiliation?
Milord.
Yes, my
If the recognition is withdrawn.
Milord.
Sorry,
and
we get
Milord,
information. I understand. That's why we are asking you. Get information by Monday about the withdrawal of recognition with this
Okay.
college.
Milord, I'm,
Then I have not received any copy.
No, no.
I am giving, my lord.
Huh?
Today on that day, my lord, he was not available. So I am
Just,
giving.
I cannot, senior sir have informed me
Oh,
in
then,
I inform morning time.
the morning.
Milord, that
oh, then it will
maintainability
be, I think he'll not be able to do it. Wednesday then.
Wednesday.
Wednesday.
Oh.
Milord, that maintainability aspect, Milord. Since Milord, the locus standi of the petitioner, Milord.
No, we are not issuing notice right now.
Milord.
You get
On
information
Wednesday,
instructions. We are not issuing notice right now.
Milord.
But when he says that the affiliation was withdrawn by NICT and then they are carrying out the affiliation
Affiliation, my lord. This is very heinous crime, my lord. they have
as a
done.
case.
And there is a paper publication also there, my lord. News item also coming, my lord, after him.
Uh,
Friday. Friday.
We'll take a look.
Mr. P. Mohanty and counsel for the petitioner, as well as Mr. P. J. Fukan and standing counsel for Guwahati University, representing respondent number 1, 2, and
1, 2, 3, and 4.
1 to 4. For school education, who is there?
My lord,
6.
Supplementary. I'll do.
Upaminna is there, I think. Vedanta is there, no?
B. Kaushik.
Kosik, yes, Kosik.
Kosik.
B. Kosik is there, my lord.
You did not serve copy.
My lord, that was not, at the time, my lord, not available, and that is why I filed, my lord. I
Well, you can't give it like this. When there is a standing counsel, you could not have filed it.
No, at that time, my lord, I was trying to get it on telephone, but nobody was responding, my lord. This is the problem.
Then you should have made a mention that you made an attempt and it's not there.
But I will sort it.
No, list on Monday.
Milord,
As notice, as advance copies of the PIL has not been served on the standing counsel for the education department. You have got it?
No, madam.
No, I am also
No,
sorry.
as well as to the standing counsel for NCTE.
Milord, the matter will be listed on Friday, Milord. On Friday, Milord.
Friday.
Friday.
This Friday,
This Friday.
6. No,
Today is Friday,
even
Uh,
13.
Coming.
or
12.
coming Friday.
13.
13.
June, madam.
Okay, 13, list on 13.
Master.
Most of
The name of the entity may be shown in the call.
Okay, the registry shall reflect the name of SC/NCT in the cause list while listing, as well as SC education while listing the matter next.
Item 3.
Please, Your Lordship, in terms of order dated 28/3, Lordship, I have filed my additional affidavit, which shows that the rejection of the petitioner's Lordship in the name, in their name rejection in the draft list of the NRC, Lordship, showing that the doubtful voter, Lordship. that your lordship will find at page 50 of my additional affidavit. Okay. And prior to this publication of the draft NRC lordship, they were not aware that a case was pending against them because they were casting their votes duly. And I have annexed the voter list of 2008, 2015, 2010. The impugned judgment was passed when they were minors, lordship. Expertly ordered a passport is 1998. 1998 expertly ordered a passport.
Naran Das maybe. Naran Das or copy is it?
Sorry, number 333.
Please do not have.
Lordship, sorry,
We have a query. Why should we entertain a writ petition?
Lordship,
You see, the notice, according to the opinion
Lordship,
of the Foreigners Tribunal
Lordship.
at page, type copies at page 39.
Yes.
Copy was served to the OP. OP was Birendra Das and 5 others.
Yes.
Who is Birendra Das?
Birendra Das is the father of the petitioner, Lordship.
Father.
Yes.
In the writ petition, you have not made any statement whether your father is alive or dead.
Lordship, he is dead.
Where is that statement? Where is the death certificate? Because you see, if your
Lordship, at
father,
page 8, paragraph number 8, Lordship.
page
8, paragraph number
Page
8 of my
8,
writ
para
petition.
8.
Be it stated that Birendra Das, that is the father of the instant petitioners, passed away on 25/8/2009. He passed away in 2009, but he did not prefer any application challenging the impugned order, Lordship. That was a mistake committed by the father. And in fact, one of the brother of the petitioners, he stays in Hojai. His name is not there in the as a doubtful voter. They were not aware of the fact that
No, definitely, if you are minors, your parents took steps for you. They were your next friend and guardian,
Lordship.
and their action will bind you.
If your Lordship perishes just for a moment, page number 18. 18 is the revenue receipt, Lordship, which the father of the grandfather of the petitioners, he paid land revenue in respect of a plot of land in which he was in possession. That was filed on 25/11/2000.
But there's no land document.
Lordship. And after that, your Lordship will find at page 20 is the voter list of 1966 showing the name of the grandfather of the petitioner. Bihari Chandra Das, your Lordship will find it. Here, he was residing at Dhanuhar Basti in Hosai district at that particular point of time. At page number 22, your Lordship will find the voter list of 1970. Now, why the foreigner's case was lost against him? Because the father of the petitioner, after marriage, they shifted to Karbi Anglong. Had they resided in Hosai, they would not have any case of FT. And therefore, a statement was made by your Lordship will find that statement in the impugned order. Statement was made by the Sarkari Gaunpura that he did not see the father of the petitioner in their village. And at page 24, your Lordship will find the voter list of 1993 showing the name of the father of the petitioner at serial number 880.
You see, this copy at page 41, which you are producing,
Lordship.
this is not a certified copy. Is this a certified copy?
No, Lordship.
if this is not a certified copy, that means you are aware of this order. At least your parents were aware of this order when it was delivered.
Lordship, the difficulty is that they are not aware of the consequences of this order. And if you Lordship peruses page 50 for a moment, the final publication list of the NRC, which says that doubtful vote, which reflects doubtful voter. And if your Lordship peruses the voter list of which I have annexed, starting from page 27 to 34, these are the voter list. And in terms of this voter list, they were casting their votes. So they were not aware that what consequences actually this particular impugned judgment follows. And they were casting their votes. And when this list was published and their names did not include in the NRC, then they came to know that the consequences of this particular order. That is the difficulty, Lordship, these petitioners are facing. They are villagers who are residing in West Karbi Anglong. In fact, they could not even provide me this NRC list. I had to download it from the website. In fact, in those voter lists, they were not the voter list of 1993 to 2015. They were not. There is no remark that they were doubtful voters. So they were casting their votes under the impression that they are not. There is no the consequences of the order, impugned order, since they do not know.
Because you see this, there is a disclaimer always in this NRC. If you come to page 51,
Yes, Lordship.
you will find clause number C. Discovery at any point of time of person being eligible for inclusion in NRC or being declared a foreigner post 1971 or so and so. So therefore, this is a disclaimer.
Lordship.
Even if you are casting the vote. Call for the records,
Lordship.
Mr. Payang.
My lord, otherwise also, my lord, your lordship has decided in 5903 to 2024. In 5903/2024, your lordship has decided, even though my lord, they are found to be 66 to 71 stream. Now times has lapsed, my lord. Your lordship has
But you
decided
see,
they
it's
cannot
showing as
register.
minority.
That was
If that was a case of minority, then at least this now the age of the petitioner is 40.
In fact, the land revenue payment record shows that the land revenue was paid for the year 1954-57.
If they challenge it on merit, my lord, if they challenge it on merit, that it is valid, then your lordship may call for the record and your lordship may examine the validity of the opinion. And if they want to register, then your lordship, then the Begumjan will cover problem.
Pardon me, I did not get it.
No, my lord, if they want challenge that opinion, my lord, that it is bad in law, it cannot exist. So then your lordship may examine whether that is as per law, whether it is valid or not. And further, my lord, the delay in lapses will be there. And if they want to register now, my lord, then your lordship probably the Begumjan will cover, as your lordship has passed an order in Begumjan 5903/2024, that order dated 9/1/2025. In that case, Begumjan will cover.
In Begumjan,
Please
your
give a
lordship has
copy.
provided a specific time limit because of Rule 9 of the.
Because in this case, there was no direction to have it registered.
Yes, that is also their lordship.
No, but
So
the
therefore-
registration, it's not the direction, but the tribunal cannot give direction. Tribunal is to give the opinion only. Tribunal, in fact, now, my lord, in fact, they can be deported also. That they may be deported also. That can also be cannot be directed. So tribunal cannot give direction, my lord. That is settled position. It can give opinion. After the opinion, it is the consequential, my lord, orders, whatever has to be passed by the, my lord, executive authorities.
The repetitioner which my learned senior friend is referring, she has approached this honorable court seeking time for extension of time limit, which your lordship held that could not be provided. And since there was no direction in the impugned judgment, so therefore the instant petitioner, the father of the instant petitioner, he could not be held accountable for the fact that there was no direction. Had there been a direction to register his name,
No, he has a point. The issue of direction will never be there.
Yes, it's an opinion
It's
also.
only an opinion.
otherwise also lordship, it's an expertise opinion. It's a undoubtedly lordship, it's a mistake committed by the father. In my humble submission, lordship, the petitioners who are citizen of India, they should not suffer for the mistake of their father, lordship, for the fact that he did not approach this honorable court at that particular point of time.
Registration.
Registration declaration of the report of the station may only regarding. NRC is common. কিন্তু ভোট দিয়েছে।
Learned counsel for the petitioner.
Lordship R Bora.
Sorry, R. Bora, learned counsel for the petitioner. Mr. Respondents are there, Mr. Adhikari, CGC, and Mr. Kalita for on behalf of Ms. P. Barwa. Before issuing notice in this case, the court is inclined to examine the records of the learned tribunal. If accordingly, the registry shall requisition the records of page 39. First will be FT case number, second will be police reference case number. Disposed of by, passed by the Learned Foreigners Tribunal, Karbi Anglong Difu, by an opinion dated 28/4/1990. Mr. Payang, where would be the records available? Foreigners Tribunal Difu.
Yes. There is only one point.
Only one. Okay. Next one, the registry shall send the requisition through email to the following email address of the Learned Tribunal. Give a date after 2 weeks. List in the motion column on so and so.
Published.
Item 4,
My lord, in this case, petitioner was declared post foreigner,
Which page is the opinion?
page 23 onwards. My lord.
'23 opinion. We have to wait for some time for bail until we get the records.
Okay.
Heard Mr. A. Paul and the counsel for the petitioner. All the respondents are there. Opinion page 23, opinion dated
22nd March.
22/3/2023. Passed by so and so and so and so. R case number so and so. Declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice extra copies within 2 days, call for the records. Give a date after the vacation, fixed date, list on so and so. The
16th of June, July, 16th of July.
registry shall requisition the relevant records from the concerned tribunal by sending requisition through email at the following email address of the said learned tribunal. Next, the prayer for bail shall be considered on receipt of records. List on so and so.
In the meantime, she should not be detained and deported.
No.
Published.
Item 5,
Yeah, please, your lordship. It's an ex parte opinion at page 14.
2019 opinion.
Yes, yes. LCI may be called.
Okay. Sir D.K. Agarwal on counsel for the petitioner. Ex parte opinion dated 16/2/2019, page 14. Notice extra copies within 2 days. Call for the records. Give a fixed date after reopenings.
16th of July.
The registry shall requisition the records for which requisitions be sent by the following email address of the said learned tribunal. Next, the prayer for bail shall be considered on receipt of records. List on so and so.
Much obliged.
Item 6,
Please, your lordship, ladies and
Open-ended page. Oh, this securitization.
yes, your lordship. Lordship, I have been granted a loan from the Canara Bank on 9/11/2018 of 20 lakh rupees. From then till April, I have been paying the interest amount along with the installments duly. But due to some inconvenience, on April 24, I have been a defaulter.
Yes.
Accordingly, they have issued a demand notice towards me as well as the sanction amount on 23. They have issued two demand notice. First was on 21/2/2023 related to this default notice. And then again, they have issued in 22/7/2024. Your lordship, I have been defaulted till April 2024, but after that, I have been repaying the loan as well as the instant interest amount. But thing is, on 18/3/2025, the District Commissioner of Borpeta issued a notice. Your lordship can see at page number 35 of the writ petition. The District Commissioner has stated an impugned order regarding directing to the Superintendent of Police for attaching the land property of mine for the recovery.
Yes.
So, your lordship, my submission is that as I have been a defaulter till April 2024, but after that I have been paying the interest as well as the.
You approach the tribunal, there's a debt recovery tribunal.
Your lordship, that's the, so.
This is something we can't handle. What is the amount due, what is not, we will not make the arithmetical calculation.
Your lordship, I have also given the bank statements.
I understand, but I have no way to make the calculation and to find out whether you are a defaulter or not.
Your lordship, the query is that the commissioner has no jurisdiction under this thing. It is out of his jurisdiction.
Have you read the Securitization Act? You are making that submission after reading the act or without reading the act?
I have read. No, lordship, what I am saying is that there are other tribunals and forums where they can actually go and register this thing.
Even that submission is made after reading the Securitization Act or without reading the Securitization Act? Have you read the act? Third time we are asking you. Have you read the act?
Your lordship, not
Then
provided.
we are dismissing it. Next time you read the act and then come.
Your lordship, just kindly grant a date for that, because
For reading. Very good.
all I'm saying is that the interim order passed by the DC on 18/3 just said should be set aside and paused.
We are dismissing the writ petition. Heard. Mr.
As Bora.
S. Bora, learned counsel for the petitioner. Also heard.
It was it.
Mr. P. Sharma, learned additional senior government advocate, appearing for respondent numbers 2, 3, and 4. 2, 3, 4, and 5 also. 5. For respondent number 1. Okay, Miss Anne Bordelais, learned standing counsel for the land and for the revenue department, representing respondent number 1. Next paragraph. By filing this Securitization Act, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 18/3, order number. This is at page
35, your lordship.
35.
Last page.
You copied from page 33. Number so and so. Issued on 18/3/2025. By the Additional District Magistrate Borpeta. Initiating recovery under Revenue Recovery Act against a defaulting government employee. In the case of Paran BED, Bachelor of Degree, B.Ed College. Against the petitioner, who is the proprietor thereof. Full stop. Next para, as per the contents of the said notice. The recovery proceeding has been initiated on an application received from the authorized.
May I please, your lordship? Pardon me. Your lordship, I am ready to pay the defaulting amount. All I'm
We
just
can't do
saying is that-
anything. You go to the tribunal. The authorized officer, Tejpur Regional Office, Canara Bank, Borpeta Road Branch, regarding initiation of recovery under the Revenue Recovery Act. Next paragraph. The learned counsel for the petitioner contends that there are specialized tribunals and courts to enforce recovery of the bank dues. And therefore, the mode in which the money sought to be recovered is not sustainable. So he also submits that, he has also submitted that although the petitioner has availed a loan from the Canara Bank and was a defaulter at one point of time, however, the petitioner has been repaying the loan and interest dutifully after 2025, year 2024, and therefore such recovery could not have been initiated. Next paragraph. From the documents appended to the writ petition, it appears that the Canara Bank, in the packet respond number 6, has issued notice under section 13 within packet 2 of the securitization and reconstruction of financial assets and enforcement of Security Interest Act, 2002, within bracket SURFACE Act for short. Next, under such circumstances, if the petitioner is aggrieved by any action initiated under the SURFACE Act, the said act provides for an alternative and efficacious forum for the petitioner to agitate any point he desires to press against the recovery sought to be made by the Canara Bank. Next, even otherwise, if an action is initiated under the Revenue Recovery Act, efficacious remedy is provided for under section 4 of the said act. Next, under such circumstances, as alternative and efficacious forum is provided to the petitioner to agitate his grievance under under circumstances where recovery notice has been issued under the Surface Act and the Revenue Recovery Act, 18, it will be 1890, the court would not issue a writ. First off, accordingly, this writ petition is found without any merit as alternative efficacious remedies available to the petitioner. So accordingly, this writ petition stands closed with liberty to the petitioner to approach the appropriate forum in accordance with law.
Item 7.
Okay, is this your lordship? I made a mention for withdrawal. Reason also I've written, but inadvertently I have ticked motion, so it came in the motion column, lordship. So I want to withdraw this writ petition with the liberty to file afresh. I have not moved this petition as yet, lordship.
There's some, you said some error there.
Yes, lordship, this is the reason.
Item number 7. Is that not so withdrawn?
29.
29, all these cases, I got the instruction.
Pardon me, please repeat again.
I got the instructions, my lord, as your lordship asked me to get the instruction. And what happened, all those cases, they have said they have not received notice, they're coming, my lord. Now they have given numbers of statement, they have not received, they are, my lord, tortured, they are inhumanly, my lord, without any authority, they are detained. My lord, they have received notice by themselves.
No, that's okay. But if she says that there's a defect, let her present appropriate.
No, my lord, that abatements may be, my lord, accorded, because they have said, my lord, they may give a different, my lord. Now they may different, my lord, take
No,
different.
for that you'll have to raise it that you see, once she says that there is an error,
Yes.
maybe that statement itself is an error. So we would not prejudge the issue.
This
Somebody is
petition-
withdrawing it without moving the motion matter.
No,
It's not that the
earlier
motion.
one was moved. my lord.
That's okay.
Item-
If there's an error which the petitioner comes and tells us.
Item 29, my lord, there is a,
No,
they
you-
moved it.
You see, you may make a mistake.
Yes.
But when you want to withdraw it, that statement, it is gone. Some mistake may have happened. We are not prejudging the issue that why this mistake happened, why it not. Somebody says that it may be wrongly instructed.
Yes. It may be different issue, but my lord, only my point is, my lord, it's a abuse. Otherwise, my lord, I was, last occasion, they asked me
Had
to
she,
get it.
had she moved it and got an order,
Yes.
then you
earlier
would have,
they-
then
they-
you would have said that
my
it's
lord,
a.
item 29, they moved it. I was directed to get instruction. I invested my time, my lord. I get the instruction, everything. I got the order copy as your lordship directed me to get the order.
Time is of no consequence here.
When may I submit? My
Because-
friend is.
Because Mr. Payang, if we go by the time, you take a call. No, not that. You take a very, all of you sit down together, think over and come to us on Monday. You tell us that time is the essence in the writ petition. You just have to tell us that yes, the adherence to time would be there and the time is of value. Just tell us and then we'll take a call. You take it up on Monday?
Not issue, my lord, your lordship, but only my point is, my lord, they have given a statement that they did not receive notice. But now as they got the certified copy, they could have waited for 2 days. They could get the certified copies. They applied for.
Those
They
things-
listened to it.
Those things, we are not here for sermoning.
Yes. My lord, because there are numbers of allegations against the officials that, my lord, they have done this.
But they are
that, this.
withdrawing it.
Yes.
Are you still aggrieved? Do you want the allegations to stand?
No, my lord, if they.
No. This is unnecessary. It's absolutely unnecessary. Once somebody comes and says that there's a mistake, we want to withdraw it, the end of the matter. They're not issuing a futile writ. Upon instructions, Mrs. D. Ghosh, and counsel to the petitioner, submits that there are some mistakes in the writ petition and therefore she desires to withdraw it with liberty to approach again. Although all sides are represented, all the respondents are represented, although Mr. J. Payang and counsel for the FT matters has opposed the prayer, If court is inclined to allow the prayer, the matter is dismissed for withdrawal with liberty as paid for.
Deeply obliged.
Mr. Payan, you will find a judgment. It's reported in SCC. I forget the citation. I'm very weak in, my memory is very weak. It's called Mahila Ramkali. You,
I'll second.
it's a judgment by the Supreme Court of India. In the second round of litigation before the Supreme Court of India, the court permitted the plaint to be withdrawn and then to amend it and file it again. Second round of litigation, and if you count the years there, you will find that the prayer for amendment was allowed after 40 years.
That can be disparity.
So
In some cases, that may be definitely injustice. should
so
not be there.
while you were spending time getting instructions,
Not on that.
it is during that time I read this judgment.
No, my lord,
Mahila Ramkali.
my lord,
Read
because
it.
my lord, the matter is very sensitive because they are taking this matter to
No, we
the
understand.
out of the jurisdiction
let-
also, out of the court also. So now, my lord, that's why. My lord.
Let it happen.
Now, when the truth comes out, my lord, they are withdrawing this matter. Let
It's
it-
okay.
Item 8.
May it please your lordship. Lordship, it is a contested matter. Impugned
Where is the opinion?
order is at page number 99, lordship, annexure 26, dated 18/1/2021, lordship. Lordship,
21. Then we have to wait for some time for bail.
lordship. It's a very long order in petitioner.
Pardon me?
Lordship,
Pardon me, please repeat again.
lordship, kindly interim protection may be granted.
No, no, when you are delayed in 2019, she
Lordship,
would be more influential than us.
for deed of will, lordship, and so many documents exhibited, lordship, and kindly lordship allow her
No, no,
to make
no
lordship.
introduction. Third Miss
H. Ahmed,
H.
H. Ahmed.
H. Ahmed. Okay. Next time you take. Okay, Miss S. H. Ahmed, then counsel for the petitioner. Next. Opinion dated. Page 99, 18/1/2021,
Lordship.
passed by so and so in so and so IMDT case number so and so. SP reference number so and so. There are two reference. Declaring the petitioner to be a foreigner post 25/3/1971 stream. Issue notice returnable on the same day. Extra copies within 2 days. Let the relevant records be called for from the concerned tribunal at the following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of records.
Obliged.
We can also provide that if you want to give a certified copy to the learned tribunal for sending the records expeditiously, we can give you that liberty. If you file the certified copy, the sending of records will be faster. You want that?
Lordship.
Okay, also before that, last line, the petitioner is also at liberty to produce the certified copy of the order before the petitioner, through her counsel is at liberty to produce a certified copy of this order before the learned tribunal so as to expeditiously send the records. This also also.
Obliged.
Item 9.
May I please, Your Lordship?
Yes,
My lord, the imping opinion at page 70, my lord.
70,
70, my lord.
24. Oh.
Yes, my lord. 11, 26, 11, 2020.
Okay. We give protection to the
Yes,
petitioner.
Doctor.
But Mr. S.A. Ahmed, learned counsel for the petitioner. S.A. Ahmed, learned counsel for the petitioner. Opening at page 70, 26/11/2024. Notice extra copies within 2 days, call for the records. If prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the prayers, projection made in the repetition. 10 days time to take bail or rupees 5,000 to the satisfaction of
Bulaghat. SP Bulaghat.
SP
SP
Bottle.
Bulaghat. Oblige.
Item 10,
May I please, Your Lordship? Lordship imposed an order on dated 7/1/2021, imposing 31.
Opening is at which page?
Page number 31.
21. It's a 21 opinion.
21.
You have to wait for some time for bail. You're not giving you interim protection now. Heard Miss M. Ahmed,
M.
learned counsel for the petitioner. The responses are there. Page 31, opinion dated 7/1/2021. Passed by so-and-so in case number so-and-so, FT case number so-and-so. Declare the petitioner to be of foreign opposed 25/3/1971 stream. Notice returnable on
16 June,
16
July.
7/2025. Extra copies within 2 days. Requisite, relevant records be requisition by the registry by giving, by sending email, send notice by email by following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of records, list on so and so. You also want the liberty to give a certified copy before the tribunal so that the records will be expeditiously sent. Okay. Yes, item 11.
11.
Mr. Das, opinion is at page 30.
19.
Opinion is at page 30. Opinion is at which page?
Opinion is at page 30. Yes? Opinion.
So I've got documents of 66.
No, opinion is at which page?
Yes.
Which page is the opinion?
Opinion at page, my lord.
30.
Opinion is that there is a illegal matter at this page, 58, my lord.
58.
My lord, in this case, 2 witnesses were examined and final documents were,
But this is 2019.
yes, my lord.
We'll call for the records. You'll have to wait for some time for bail. We are not giving you interim protection. At this stage, we are not giving you interim protection.
That I have given an explanation in the para 12.
No, but 2019 is long 6 years.
That's not,
You have to wait for some time.
I had the idea that in writ petitions, delay the other matter, my lord. My lord, in the opinion at page 4, from from para 4 to para 6, my lord, may be seen what the learned tribunal has said. Learned tribunal gave the opinion only because, my lord, the petitioner failed to adduce additional evidence. Only on that ground, my lord. And another thing, my lord, the three descendants of the same person, Musabbir Ali, has been differently given the opinion by the tribunal. The son of the Musabbir has been declared to be not foreigner, my lord. And the grandson of Musabbir Ali has been declared to be a foreigner of 6671.
We'll call for all the three records. The other opinions are at page 30 and page 25. Two opinion or three. How many opinion are there? Two or three? Three opinion.
How many opinions are there? Huh? How many opinions are there?
Three opinion.
How many opinions? My lord, so we have submitted three opinions, my lord.
Three opinion. Okay.
Yes, my lord. One is at page 25.
Okay, we have seen that.
Another is at page 30. And the last one is at page 58, my lord.
Okay.
In
Then
one of the-
Mr. Sharma,
Lord.
if his apprehended shall not be deported. The three opinion of the same family.
Lord.
Heard Mr. B.C. Das, learned counsel for the petitioner. All the respondents are there. Right, filing this petition, challenge order, opinion dated, page 58. Opinion dated 8/4/2019. Passed by so-and-so and so-and-so. Text para. The learned counsel for the petitioner submits that the petitioner draws her legacy through her grandfather, Musobi, M-U-S-O-B-I, Musobi Ali. And though the petitioner has been declared to be a foreigner, three other descendants of her grandfather have been opined to be not a foreigner, for which, for which he refers to opinion dated 19/6/2007, passed by so-and-so in so-and-so. Give a dash. State versus Mohammed Monuruddin alias Monor Ali. That is number one. Number two. as modified by an order dated 23/2/2015 passed in the same case. The number 2 is opinion dated 30/8/2024 passed by so and so and so and so, page 30.
Is
Here is the
declared for
date
final, Lordship.
versus Muhammad Abdul Subhan.
Is declared as foreigner, Lordship.
The foreigner of 66, 70 on history, my lord, it was like that.
Whereby the said proceeding was declared to be a foreigner of between 1/1/1966 to 25/3/1971. So there are two opinion only. Two opinion only. Not three.
My lord. So I have submitted 3 opinions. One is of Muniruddin, my lord. It is at page 25.
Yes.
He's the uncle, father, brother of the father of the petitioner, my lord.
No, opinion only, you are giving only two opinion or three opinion.
Three.
We are altogether 3 opinions.
Altogether three, okay. Next para. Issue notice returnable on so and so. Extra copies within 2 days. Let the relevant the records of this 1 to 3 be requisitioned by the learned by the registry from the concerned tribunal. To stop the requisition shall also be in addition to usual requisition, the requisition by email shall also be served on the following email addresses of the following of the concerned tribunals. Next para, the prayer for bail shall be considered on receipt of records. Next para. In view of the other two opinions, referred by the learned counsel for the petitioner, the court is inclined to provide that in the event the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court.
Item 12.
Report করবো না লাগবে গেছে। Report করবো না লাগবে গেছে। কম এটা করে দেবো।
Yes, which page is the opinion?
Lordship, there are 2 opinions against the same Lordship proceeding. Annexure 9, page 70 is the first opinion given by the
Page?
land. Page 70, Annexure 9,
70.
Lordship. By which he was declared Indian and against the same reference case, he was declared foreigner.
But Mr. L.R. Mazumdar and the counsel for the petitioner. For the respondents are there. Opinion dated 30/11/2024. Passed by the learned member. Page 71. by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next para. The learned counsel for the petitioner is referred to a previous opinion dated 8/1/2014, passed by so and so, page 70, whereby the reference made against the petitioner was rejected and dropped, and therefore not proceeded with. Comma, declaring the petitioner to be a citizen of India by birth. Notice. Extra copies within 2 days. Call for the records of both page 71 and 70. The prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in this repetition, 10 days time to take bail of 5,000 to the satisfaction of SP border. Which place? Dubri. List also.
Item 13.
The proceedings, family members are before your lordship. The proceeding, it was a posthumous declaration, lordship.
Pardon me?
It was a posthumous declaration, lordship. He was expired in the year 2017. And subsequent death certificate was produced before the tribunal. In spite of that, declared him to be.
Because there is a judgment of High Court saying that the reference once made cannot be dropped, or it will not wait. There could have been a substitution by others. So, which page is the opinion?
Page lordship at 42, lordship. Page 42, lordship.
42. You are the, who are you?
Lordship, petitioner one is the wife and rest are son and daughters.
Mr. Yu Datta, and counsel for the petitioner. The respondents are there. Next will be by filing this petition under Article 226 of the Constitution of India, the petitioners who are the legal heads of late Muhammad Abdul Ali, MD Abdul Ali, have assailed the opinion dated 30/5/2022, page 42, passed by so and so and so and so, thereby posthumously declaring the said proceedee to be a foreigner of post 25/3/1971 stream. Expiration notice returnable on returnable in 4 weeks. requisite extra copies of the writ petition be served within 2 days. List on so and so, receipt of records of the tribunal. List after 4 weeks on receipt of records of the tribunal.
Item 15.
Very little lordship. My lord,
14.
impugn order is page 68. My lord, my grandfather's name appears.
Opinion at page.
Impugn order page 69, my lord. And the fine, my lord, 40% lordship may see the ground on which the learned tribunal has rejected my pair. Page 78, bottom kindly see.
24 opinion, November 24th.
Okay, heard. Mr. M.U. Mahmood, Grand Counsel for the petitioner. The responses are there. Page 68, opinion dated 27/11/2024. Notice, call for the records. Extra copies within 2 days. The prayer for bail is opposed by the learned standing counsel for the active matters. Considering the projection made in this writ petition. 10 days time to take bail or rupees 5,000 to the satisfaction of
SP Gwalpara.
SP Border Gwalpara.
I love lordship.
16.
May I please about that? Opinion is at page 16, my lord. He was declared as foreigner in 2016, my lord. Then, my lord, he was released, my lord, pre-COVID, my lord, pursuant to the order of the Honorable Apex Court, my lord, 3 years condition, my lord. Now, my lord, he was picked up on 25/5, my lord. But he'll be in the second category, my lord, covered by the Rajugala's order, my lord, 4 to 25, my lord, where the verification process is to be carried out, my lord. He'll be similarly situated with those, my lord.
Other cases are fixed on Monday, my lord. This matter may also be fixed along with 3101/2025. No? Same. Fixed on Monday, my lord.
Sort of 4 to 25, my lord, there's 2 categories where, my lord.
Okay.
Monday. Sure.
Nine.
Relevant facts, opinion dated
My lord,
page 16, opinion dated 7/11/2016. Name of the proceeding.
Samsud Ali. Petitioner's father.
Name of the proceeding is
Samsul Ali.
Samsul Ali.
Ali.
In your petition, where you have given your father's name,
My lord.
SAMSUL.
SAMSUL.
Huh. We are checking it because last time we had a problem.
Yes, my lord.
Page 16, it is Mohammed Shamsul Ali.
Yes, my lord.
Here, that MD is not there.
My lord. Sulali, my lord. He is basically, my lord, prefix, my lord, which is given, my lord, like Mr. and Miss, my lord, Mrs. my lord. That is in, my lord, my lord, opinion was referred as.
So we are checking it because there's some issue arose there in one of the matters. He was taken into custody on,
Taken into, he was released after 3 years, my lord, lordship will find.
no, presently he was taken into custody on
7/11/2016, my lord. Yeah, paragraph 8, my lord, I've said.
No, no.
No, no.
Now, when he was arrested,
Well, 25/5, my lord.
25/5.
25/5.
Okay.
At about 11:30 PM. my lord.
Okay, we've seen the same date, 9/6.
Item 17.
May I please, your lordship?
Opinions at which page?
Page 58, lordship.
38.
Opinion dated 9/8/2024.
Page 38,
58, lordship.
58.
Opinion dated, lordship, 9/8/2024.
9/8/24. Okay. Your name,
M. Hussain on behalf of R. Ali.
Mr. M. Hussain, Learned Counsel, appearing on behalf of Mr. R. Ali, Learned Counsel for the petitioner. Respondents are there. Order dated 9/8/2024, page 58. Passed by so-and-so in case number so-and-so, R reference case number so-and-so. Declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice extra copies within 2 days, call for the records. Prayer for bail is opposed by the Learned Standing Counsel for the FT matters. Considering the projection made in this writ petition, 10 days time to take bail or rupees 5,000 to the satisfaction of
SP Border, Borpeta, lordship.
SP Border Borpeta. List 4 weeks on receipt of records.
Deeply obliged.
Take a short break and come back.
Lordship, if I may, Lordship, item number 30 and 31, Lordship. A connected matter, Lordship, has already been done in court number 2, your Lordship, and the particular court has directed the matters to be listed on 11/6, your Lordship.
Connected matters were taken up before court number 1.
2, your Lordship.
Okay. So you want to be listed with, on the same day?
Same day.
Along with this, the earlier matter?
Lordship.
Okay. Education was there?
Lordship, I informed them, Lordship.
Okay.
I've informed them.
Both sides are represented. Mr. N. Gautam, Learned Counsel for the appellant, submits that a connected matter was listed before the division bench 1.
Oh.
And they said connected matter was ordered to be listed on
11/6/2020.
11/6/2020 5.
Five, Lordship.
Stop accordingly. Next matter. Accordingly, please that these two matters be also listed along with WA
184 of 2020.
184 of 2025.
Lordship.
Next matter. Accordingly, the matter stands adjourned today. List the matter on 11/6/2025 along with WA 184
Four, Lordship.
of 2025.
Lordship. That-
Separate orders, sir.
Supply item for motion, item 27.
Lordship, my lord, here this case, my lord, the petitioner has been taken on custody on 25th of May. He was, the police visited the house of the petitioner and claimed that his son may be sent to the police station, Nagarpara police station. He, on arrival to the police station on 25th May at about 12 noon, he was arrested and then sent to the Goalpara Reserve Police, thereafter sent to detention camp, Matia. And now they are not saying where about the person, my lord.
Okay,
That
what is the status of the writ petition?
My lord, status is, my lord, he is mother of the victim, my lord.
Petitioner.
No.
The writ petitioner, my lord,
No.
yes,
You made a statement somewhere
my lord,
that your son was a proceedee.
yes,
An opinion was passed. This opinion was challenged before the High Court.
my lord.
I am asking about status of that
My
writ
lord,
petition.
that petition is pending. The order one. My lord, the last order, my lord, I have annexed in the writ petition, my lord, at page 20. Lordship may kindly have a look at page 23. At page 23, there is an order dated 7/6/2021. At the time of filing, the son was in custody. And the Sonal Court has directed to release if not released. But before passing this order, 2-3 days ago, he was released in my lord pursuant to the Honorable Court's order, Supreme Court's order, and he was attending regularly. His last attendance, my lord, I have annexed, my lord, the attendance enter and attendance data I have annexed as annexer at page 27. His last date of attendance was 19/5/2025. The vernacular copy of the attendance record I have annexed. It is annexer at 4, page 29 onwards. The last page, lordship will find page 42, 19/5/2025. Attend at Goalpara police station.
Okay.
So he was attending all along. And this order of this Honorable High Court was also placed before the authority. There is the order one, each petitioner. This is an order one. Person.
Listing on any.
Hmm?
Should list on any.
Issue तो है नहीं.
Mr. Payal,
Well,
if his, so far as in the present case is concerned,
yes, ma'am.
we'll also issue a notice on bail. Because if the petitioner is attending the Goalpara police station,
Yes.
then he's covered by the earlier bail of this court.
Yes.
There will be no default. In the meantime, he is not to be deported.
In fact, I have the instruction, my lord. He is there in Matia. I have taken the instruction in fact.
He's in Matia
Yes,
Goalpara.
my lord, yes. Is
Okay.
Hasinur.
Yes. माका तो हैरान नहीं है सर.
Okay. Heard Mr. A.R. Sigdal and counsel for the petitioner. Are the respondents are there? Next para. The learned counsel for the petitioner, by,
Hasinur is at Kokurajar Holding Center. Sorry.
okay.
Brother. Here 9.
By referring to Annexure 4 to the writ petition, the learned counsel for the petitioner has submitted that pursuant to order date 7/6/2021 passed by this court in WPC 2546 of 2020, the petitioner was released on bail on certain conditions. Which are made a part of order dated 15/4/2020, passed in WPC Suomoto number 1 of 2020. And it is submitted that the petitioner is relying on Annexure 4 to this writ petition to show that the son of the petitioner, namely, what is the name?
Hasinur.
Where I'll find the name?
Well, Lordship will find in the writ petition at page 22. In order also recorded.
Okay. Hachinur, Hacinur, alias Hasinur, Hasinur. Was all throughout attending the Gwalpara police station, and his attendance has been recorded by the officer in charge of the said police station. The last appearance, having been made on 14/4/2025.
No, my lord, it is 19.
19/5/2025. With previous appearance on 12/5/2025. And 5/5/2025. Next part is submitted that despite appearance before the Gwalpara police station, the son of the petitioner, namely Hasinur, alias Hasinur, was taken into custody by the Border Police of Gwalpara district on 25/5/2025. And since then, and not since, and thereafter, he was initially taken to the Gwalpara Police Reserve and thereafter taken to Matia Detention Camp. Make it transit camp Matia Gwalpara. First off, it is projected that when the petitioner and other family members went to the transit camp at Matia Gwalpara, they were informed that the son of the petitioner is not available in the said transit camp. First off, at this stage, the learned standing counsel for the FT matters has submitted that as per instructions received by him, the petitioner's son, namely Hasinur, alias Hasinur, is currently lodged at the
Kokurajar Holding Center.
Kokurajar Holding Center at so-and-so.
Yes.
It is there in the last order.
7th APB petition.
At care of 7th APB.
Assam
Police Battalion.
Yes. Saraikula.
Spelling, please tell the spelling.
Saraikula, SAR, CSARAI, Sarai, KSULA, Saraikula.
In the district of Kokrajhar. Next paragraph. Court is inclined to issue notice returnable on when? Monday or Wednesday?
Maybe Wednesday, month.
Okay, returnable on Wednesday is 11/6/2025. Extra copies of the writ petition be served on the learned CGC State and Department Council in course of the day. Next para. In that notice, you also say issue notice including notice on the prayer for bail is issued returnable on so and so. Next para. In the meanwhile, the Superintendent of Police Border which district?
Well, this is Kamrup
Well,
Metro.
Malad,
So DCP board.
his proceeding was in Kamrup.
Okay,
So initially, my lord, bail
okay,
was
okay.
executed in Kamrup, subsequently
Okay,
referred to the Gwalpara.
Deputy Commissioner of Police Border Kamrup to Guwahati. Will take steps so as not to deport the son of the petitioner, namely Hasinur alias Hasinur, from the country without order of the court. Next para. The learned standing counsel for the FT matters shall communicate a downloaded copy of this order to the Deputy Commissioner of Police, Border Kamrup Metro, Guwahati, within bracket respond number 6. Post of it is also provided that on receipt of the communication, the respondent number 6 shall ensure that a copy of this order shall also be sent to the Kokrajhar Detention Holding Center.
Yes.
And a copy of communication so sent to the Kokrajhar Holding Center shall be produced before the court through the standing counsel for the FT matters on the next date of listing. Next para. The petitioner is also at liberty to produce a certified copy of this order before the Deputy Commissioner of Police, Border Kamrup Metro, Guwahati, to bring the order to the notice of the said authority. List on so and so.
Deeply.
Item 28 for motion.
Yes.
কোনটো ক'ত আছে গম পাইছে নেকি?
মই কেনেকে গম পাম?
My lord, in this case, I was supposed to get the instruction. My lord, the detainee Wazuddin is in Matia Holding Center, my lord, as of now. And the tribunal's order, my lord. It's also an ex parte order, my lord. It was of 30/3/2019. Yes, my lord. Last page is the, my lord.
Page 2, we can't read.
This.
Lordship, I have the certified copy. I can provide. Others. And even the process server report also is there.
Mr. Pang, we request you to call for the, this tribunal's records.
Yes.
And in the meantime, you
Record
also,
will call for more, no issue, my lord.
and in the meantime, you also file a copy of this by way of an affidavit.
Yes, Lordship.
My lord, the process server reports reveals, my lord, that he was working in in a company, and that was served in that place.
If you have noticed that, then we'll send you this certified copy. Raji. Now, this is the notice.
Yes.
Please read the address.
Care of Sri Subroto Hore, son of late Bani Prasant Rajani Gonda Founded SOS Road,
Yes.
Ajara.
Now, please tell me that without the correct address being given or whatever address being given, what business did the process server had to go to Rajnigandha factory? Can a process server, without going to the registered address, go to another address to serve summons?
This notice was to that address only.
This notice is addressed where?
To Wajuddin, son of Javed Ali, care of Sri Subroto Hore,
Yes.
son of
So
Bani
why did the process server go to this Rajnigandha factory?
No, my lord, this is Rajanigandha factory is there. Rajanigandha factory, SOS Road. Address.
No, that is the address given in the complaint petition. Please send back this. Please send back this copy.
Address of notice, my lord. Okay, you have made a point. You still call for the records. Yes, record may be called for noise.
But there he did not reside. That was his workplace.
That's five F.
No, we don't know, but that's why I missed it out that Mr. Payang has pointed out. That is the address even in the opinion.
Yes.
That was his workplace. But
Five
there
F, that's why I'm saying that five F it
Okay.
covers.
Uh,
Three five F. Three five F would work best.
But Mrs. D. Ghosh and counsel for the petitioner. All the respondents are there. Pursuant to order dated 3/6/2025, the London Standing Counsel for the FT matters has produced a scanned copy of the party opinion dated 30/3/2019. Together with a copy of the notice in the process service report. In view of the manner in which processes shown to have been served, the court would like to examine the records. Next, accordingly, the London Standing Counsel for the FT matters is requested to procure and produce the records of FT case number
1435.
it will be FT within bracket K, again within bracket M, bracket closed, -4, for the second bracket closed, 1435 of 2017, arising out of FT case number 27 of 2015 from the Foreigners Tribunal, 4th Kamrup Metro, Guwahati. Which shall be done through the concerned officials of the Home and Political within bracket B Department, Government of Assam. And is presently at
My lord, Matia Detention, Matia Holding Center.
Most of it is also submitted that at present, the elder brother of the petitioner, namely Wajuddin, is presently being
Matia Holding Center.
detained at Transit Camp Matia, Gwalpara.
It's said, Madam, Matia Holding Center.
Matia Holding Center.
Yes.
Okay. Matia Holding Center, Gwalpara.
Transit.
Next para. The court is inclined to grant to the petitioner Bahajuddin and other family members visitation right to the petitioner at Matia Holding Center, Gwalpara, to meet the detained person, namely Wajuddin, for which the petitioner shall produce a certified copy of the order or to enable the in charge of the said center to allow the petitioner and other family members to meet the detained person, namely Wajuddin, proceeding in the hearing for referred case. Next para. For records when you'll get it by 16th. Yes, Monday, next. 16/6/2025.
My lord, with regard to visiting, my lord, they may visit in daytime, otherwise, my lord, and they may not visit more than 3 or 4% because there is some problems, my lord. I have been, my lord, reported that your lordship has passed an order for visiting. The huge number of people visiting there, my lord, it was so limited numbers, they may visit it daytime, no issue, my lord.
3 or 4 persons to visit.
Yes.
Just add that, huh? Family members, not more than 3 to 4 persons.
Yes.
Visiting. Okay, we're sending you back because we are calling for the records.
Yes. Lordship, the petitioner also may be allowed to take the signature of the detainee from the detention camp.
Once he's in detention, we are accepting the writ petition. We are not questioning your maintainability of the writ petition.
No, not that. Then I can challenge the
Oh,
impeachment.
achha, okay.
That's an experiment.
Okay. The in charge of the said Matia Holding Center shall also permit the petitioner to obtain signature of the detained person, namely Wajuddin, on the Wakalatnama which shall be countersigned by the said authority.
Deeply obliged. Lordship.
Item 18 for admission.
My lord, in this matter, my lord, on 4th of June, my lord, we filed one additional affidavit, my lord. And the notification dated 27/12/2024, so far as I have received that. It is, my lord. We have brought on record, my lord, by annexing that notification. Yeah. In our additional affidavit, my lord, paragraph 3, 4, and 5, we have taken certain grounds, my lord.
Circular sales in amount develop. But I'm got this. This one. This is so amount of member. Amount of এখন এখানে করে তোমার তো কি ফার্স্ট আমার এটা হয় আমার পেলে আমার তো কিমান অ্যামাউন্ট হয় 3 lakhs 3 lakhs হয় আমার তো বলো টেলিফোনের প্রজেক্ট করি এটা সার্কুলার ডেক ওয়াটসন মই তো দিছো তাতে আমার খারাপ দিয়ে আছে cause of unnatural death, injury, death, negligence, it is negligence of pare. due to negligence of prison staff, 4 lakh pare, amount to 4 lakh hai. Due to negligence of prison staff, amar negligence var done, 4 lakh hai. Oh, I can't 4 lakh hai. It 18 no, it will jao. Dia se. You to look on beleg kara. No, beleg ki ho hai. मेरा बेसी बड़ा हो गया है बोलो আমার 10 মিনিট স্টেপ কমফোর্টেবল খুব খুশি
Mr. Deka, this is the case where this, you are alleging that the neck was turned.
Yes, in given the jerk, my lord, and that incident.
Neck was given a twist.
Twist.
This is the case.
It is their,
Yes.
it is their allegation.
Please.
Is it better? Also, But Mr. Nath, you have seen the affidavit filed on 4th. You have seen that? There's a notification by the governor, which is dated 27/12/24. You find something strange there? Do you notice anything strange there in that notification?
That Malad I have just seen. I have just seen that.
You have noticed something there? Something very strange. You see serial number 2 and serial number 3, are they consistent?
Due to injury for torture or beating by prison staff. Due to negligence in duty by prison staff.
So when they are assaulted, you give less.
Mhm.
And when they die of negligence, you pay more.
If they are not discharging duty, then money is more.
Money is more.
Money is more.
So you are justifying, the government is justifying torture.
No, not exactly, my lord, not exactly. Ultimately, action will be taken against those persons, my lord. But the victim has to be compensated. That is why this has been brought, my lord.
Then it says 3 lakh, you have to pay them. Pay to the petitioner 3 lakh with his,
My lord, in fact, my lord, here in my respectful petition, this will not come, because
this will come to page 26.
26 of the writ petition, my lord.
I don't know if in any affidavits this has been denied. We don't know. Page 26.
Yes, my lord. 26 of the writ petition.
Yes, now see the last 4 lines.
What?
Mohd Shahabuddin in statement on so-and-so stated he found the neck of so-and-so while getting the so-and-so bath for a ritual before the cremation very flexible and loose. To this observation, the doctor of forensic medicine, SMC, has referred that the neck region has become flexible and loose due to dissection conducted to find out any abnormality in the vertebrae. But on dissection, he had discovered no abnormality in the vertebrae and were found to be in good state.
Well, this was after
But
postmortem.
he died of syncope.
By that time, postmortem was done, my lord.
And in page 25 is that twisting. To support this, there are statements at page 132.
They have said, my lord, that from a hiding, yeah, they were hiding in the shadow of trees, and therefrom they have seen. But the medical reports and other things, my lord, those cannot be discarded, my lord. Because the witnesses at times, my lord, say so many things, my lord. What? Statement of motion.
Yes.
But there has to be some sort of, if it is syncope, there should be some pressure to stop oxygen in the brain. And that can only happen normally when the neck is pressed. No, the Franco. It. Of seeing the bed. Look at this dictionary definition.
It is said, Malad, is another word for fainting or passing out.
No, but the medical cause is always the lack of oxygen in the brain.
Logic.
That may result in fainting.
Fainting. Malad, otherwise, Malad, the case is now has been registered as a complaint case, and it is before the court below, Malad.
In fact, due to our pressure in this APSC matters, have not been able to read the records.
Logic.
It was a flag there. Syncope, SYNCOPE.
Malad.
That under meaning I have got lot. A sudden and temporary drop in blood flow to the brain.
Logic. The dictionary says transient loss of consciousness due to inadequate cerebral blood flow.
And then you will find in medical dictionary also that you must have some pressure for some point of time for the blood flow in the brain to stop. There must be some neurological, what do you call, hindrance for the flow of oxygen to the blood. It may happen when a person is sick. Then also it may happen. If he is very, very sick, then it may happen. Because then when this multiple organ failure or somewhere, or if there's a chest cannot pump oxygen.
Oxygen. In that case also. Malad,
In that case also it may happen.
Malad, I have a submission, Malad. Kindly consider, Malad, if Malad Lordship Malad to that extent goes in this case and records any observation, Malad, ultimately this will have a bearing in the
It will have. That's why we are asking you.
Lordship.
Because once we say that, that's why we said, even in the last occasion, I think I said that.
Lordship.
One is that without prejudice to whatever is going on, we give a compensation and then close the matter here. So that whatever happens in that miscase after the Naraji petition is filed, that will take its own course.
It will take its own course. They will reduce evidence because all these things are there. Court will definitely consider that. These materials are there, Malad, already. This will be considered.
But as a writ court, we will require to give compensation because he died in police custody.
That is, Malad, to that extent, I also, Malad, submitted.
That is 3 lakh.
That is 3 lakhs.
3 lakh, even for torture, it will be 3 lakh. Same thing.
Lordship.
Yes,
Even if Malad, if Lordship goes to that extent, Malad, torture is proved. Otherwise, court will take a presumption that.
No, that's why we are asking you. That's why we are asking you. It is for you to give an answer. You see, so far as in this memo notification, there are 2 things. Number 1, he dies in police custody. He gets 3 lakh rupees. Then we don't give a finding.
If Malad, there is torture.
No, if it's torture, then again 3 lakh rupees. So it's the same thing.
3 lakhs. And the second one is negligence. Malad, what we have said, Malad, we have said that because of some medical reason he died. And in that case, my lord, negligence make up that
Then he gets 4 lakh.
we could not provide him the
Then
medical,
he gets 4 lakh.
whatever. Otherwise, the notification, we have to go by that. We have to go by that. In that,
You benefit 1 lakh rupees.
in that case, my lord,
Let
in-
my friend complete, my lord. I have some assumption, my lord.
in that case, my lord, everything will be open, my lord. If they can prove something more than that, then the trial, in the trial, my lord, it will
We
be
will take it some other day because we have a meeting right now.
lodged.
And at 2 we'll be taking up those APSC matters.
Lodged.
This is next Wednesday.
Yes,
Lodged.
next day, next day.
The positive matter could not be taken up today. Let's talk next Wednesday.
Someone against the telephone.
Next day.
Okay.
Item, there is one matter, item number 22, where we said order by the learned single judge, Honorable Justice Jami, that is why it was posted before this bench. Let it come after a week, my lord.
Next Wednesday?
Let it come after a week. Please don't give a date after a week.
Oh, okay. Item number?
Item 22.
Item number 22. Both sides are represented. As the court is hearing a series of parted matter, this matter cannot be taken up today. Next, just after a week.
After.
Item 20 also, my lord, may not be taken today, my lord.
All the other matters would be adjourned by default.
Yes, sir.
No, item 19, my lord, I have been detained despite the cases pending before this court, and I was released pursuant to the order of this court, my lord. I filed an affidavit, my lord. Next item, my lord.
Item number?
19, next item, my lord. I was detained but released pursuant to the order of this honorable court, and the
So-
case, my lord. And then I have
Any
been,
urgency in the orders? You want to go back again?
no, my lord, I have been detained, so I filed an
Oh,
affidavit.
you have been, you are on bail on detain.
Yes,
Okay,
ma'am.
then make it Wednesday. This one, we'll take it up on Wednesday.
My lord, my lord. Sorry.
Item 24, my lords. It is similar somewhat. It was fixed for bail today and LCA was called for. LCA is available. Whereas I am in the detention center.
Okay, same Wednesday.
Item number 23 also, your lordship.
20.
My item is 23, your lordship.
22.
Like in this case, your lordship, first time I am declared Indian, your lordship, thereafter I am foreigner, your lordship. LCR has been received, your lordship. Witnessed it.
Wednesday.
My lord,
Item number 21, my lord. My lord, the
Must-
matter is coming time and again, my lord, only for consideration.
For
of
next
bail.
2 weeks, nothing is going to happen.
My lord.
I can assure you that. Once we stop hearing that, once that hearing is ended in the APSC matters, then only we can concentrate. We don't have time.
No, my lord, it may be come on, my lord, next week on any date, my lord.
Okay, Friday then.
Friday, my lord. Obliged, my lord, obliged. Highly obliged.
It will, it's already.
So Lordship, Leadership, yesterday, I had dealt with the principles of natural justice and a whole line of judgments on that. And its alleged violation and the plea that it needs to be complied with. What I have shown through the various judgments, Lordship, that the settled law is now that there are exceptions. It does not have to be followed in each and every case. Today, I'll, Lordship, speak a little softer. My throat is today bothering me a little. And what the court or the judicial pronouncements now is that it cannot be what has been termed as a futile exercise. The word was, of course, used useless formality, empty formality. There has to be some there has to be, it cannot be a futile exercise. There has to be some real, the word used was real prejudice. And respectfully, just to close that argument, Lordship, what was placed before the learned single judge was every file relating to every petitioner at that stage, appellant now. And the learned single judge perused each one of those files, and in effect, that is why the argument of the principles of natural justice and its alleged violation has been rejected. So that was on the line of judgments on principles of natural justice. Now, Lordship, today we are giving our third compilation, which is on the proposition any order of simpliciter discharge / removal from service does not carry any stigma in such cases. And provision of Article 311 does not apply. So I am continuing the series of judgments to the next part, Lordship. Naresh was the last one I had shown of that DTC conductor in Delhi, the Delhi High Court judgment, Lordship. In furtherance of that,
Yes.
Lordship. So,
for what you said first, we are sending you something.
oh, I'm sorry. Grateful, Lordship. You will not believe, Lordship, from morning what all I've been doing to save the throat. Thank you so much. Thank you so much. I'm going to use it very shortly. I have something. Everything under the sun that can be taken, tulsi, adrak, water, kada, tea, gargles, whatever I could do, Vicks, all has been done to save me for the day.
Just to shout at me.
Lordship, in another proceeding, we have sort of paused contempt. I have no intention of starting one here. So, Lordship.
You know, incidentally, what happened was when I was practicing, at that point of time, I won't name the judicial officer who was new. He was in Debt Recovery Tribunal as the presiding officer. He came as a stopgap arrangement because our Guwahati officer was on. He was shifted somewhere else, and then from Calcutta, someone came. And when I made my submission, he shouted at me. And I retaliated and went back. And after some time, a telephone comes from the Debt Recovery Tribunal that please come back and meet sir. I said, why? But no, he has a loud voice. Even if he says something secret, it can be heard from down below.
So does that apply to my learned friend here?
No, I'm not saying that. I'm not saying that. We leave something for presumptions. So then I learned my lesson that I should be polite even when somebody
is loud,
raises voice, because I don't know what is prompting it. So
Conduct, negligence, insufficiency, or other disqualification may be the motive or the inducing factor. The Lordship, that word is very important for us. What is the inducing factor? That becomes very important, which influences the government to take action under the express or implied terms of contract of employment or under the statutory rules. Nevertheless, if a right exists under the contract or the rules to terminate the servant, the motive operating on the mind of the government is wholly irrelevant. So, Lordship, what is being laid down here is that the inducing factor, if it is relevant, then, Lordship, the motive or the inducing factor is not there, because the right to terminate or to dismiss or to discharge, as the case may be, by the appropriate thing can be undertaken. The test for attracting Article 3112 of the Constitution in such a case is whether the misconduct or negligence is a mere motive for the order of reversion or termination of service, or whether it is the very foundation of the order of termination of the service of the temporary employee. In the present case, however, the order of reversion does not contain any express words of stigma attributed to the conduct of the respondent, and therefore it cannot be held to be that the order of reversion was made by way of punishment, and 311 is applied. Now, Lordship, two things I would wish to basically say, Lordship, at this point. Not in every case it will attract. There's no quarrel with the proposition that even temporary government employees or a probationer in a certain situation may attract the provisions of 3112. That is the settled law. But Lordship, what has to be considered is what weighed on the mind of the government, the objective criteria or the objective information, which is the inducing factor. So that becomes new here. The inducing factor for the subjective satisfaction. 2, is there a stigma or not? And 3, as we have seen in the Naresh judgment, even the mentioning of the FIR is not a stigma, Lordship. In Naresh, it comes out clearly. At best, what did the court do? Order, remove this. But the inducing factor is more important than the mere mention of something in that order of discharge or termination. Lordship, may turn the page. Para 4. We are accordingly of the opinion that in the present case, the High Court was in error in holding the reversion of the respondent from the position of officiating income tax class 2 to a lower rank, as income tax was tantamount to reduction in rank, and therefore respondent was entitled to the safeguards provided in Article 31. Lordship, the next judgment is Madhya Pradesh Hastashilpa Vikas Nigam versus Devendra Kumar Jain, 1995, 1 SCC 638. Lordship, there are about 3-4 judgments that I could have relied upon, but what is coming through this is almost identical. So I'm not burdening the court with a large number of judgments. I'm just going straight to show what the settled law is. Now, Lordship may note another thing which is interesting, that the test of Parshottam Lal Dhingra and Shamsher Singh is not overruled. It is being considered in each one of these cases. What is critical is the fact or the inducing factors and the nature of the order. That's the important point we are making. Lordship may come, this is a 2-judge bench, Lordship, 1995, 1 SCC 638. Lordship, para 2, broadly saying it's a government company, Lordship. What it says broadly is that at one point of time, the managing director appointed respondent 1, 2, 3 as temporary junior managers. Then, Lordship, the company noticed that the appointments of the respondent 1 to 5 were in violation or contravention of a government order, so that they terminated the services of respondent number 1 to 5. Lordship may know that is the background. They filed, Lordship, approached the High Court, and the High Court of Madhya Pradesh quashed the termination order, Lordship. And then para 3. The High Court quashed the order of termination of service of the respondents mainly on 2 grounds, and Lordship may mark. Firstly,
This is critical because this is the view of the High Court, Lordship. Firstly, the High Court took the view that the respondents' services were terminated without giving them any opportunity of hearing, in consonance with the rules of natural justice, and therefore the order of termination of service was contrary to law and violative of Article 14 of the Constitution. And secondly, Lordship, the government approval was not necessary for the appointment as contended by the appellant, and in any case, no material was placed to show that the appointment was contrary to the government instructions. In our considered opinion, the High Court fell in serious error in taking the aforesaid view, and therefore the High Court order could not be sustained with in law. Admittedly, the appointment of the respondents was made purely on temporary basis, which is evident from the order of appointment. Then Lordship may come, it shows the various orders, Lordship, and para 5 at the bottom of the page. A plain reading of these two orders will go to show that the appointments were purely on temporary basis, and their services were liable to be terminated at any time without notice or assigning any reason. In case of an appointment on temporary basis, a servant who is so appointed does not acquire any substantive right to the post. And Lordship, we have dealt with deemed confirmation and the statutory rules, what they say. Even though the post itself may be permanent, and if it is an implied term of such appointment that it may be terminable at any point of time and without notice, a temporary government servant does not become a permanent government service unless he acquires that capacity by force of any rule, or he is declared or appointed as a permanent citizen. Now, Lordship, in our case, each one of the rules has a requirement of confirmation. That's not done. In the present case, there is no rule under which the respondents may be deemed to have become permanent by force of such rule, nor they were so declared by any subsequent order of the appellant company to have acquired the status. On the contrary, the respondents all along continue to be temporary, and according to the terms of the order of appointment, their services could be terminated at any time without any notice or assigning any reasons. Lordship may mark, in such a case, it is not necessary to follow the formalities contemplated by Article 311 of the Constitution. In these facts and circumstances, the High Court was not right in holding that the respondents were entitled for being heard before passing the said order of termination of their services, and that the order of termination was bad in law on that account. That's this judgment, Lordship. Next, Lordship, is 1995 6 SCC 534. Hukum Chand Khundia versus Chandigarh Administration. Again, two judge Lordship. This Lordship is a temporary clerk who was appointed by the District and Sessions Judge Chandigarh in 1982. Para 1, Lordship. He was continuing in service or as temporary service on probation, just under placetum B. So, Lordship, under placetum B, it marks the words, he was continuing in temporary service on probation, work was found unsatisfactory, his integrity was questionable, and his appointment was terminated. Now, what is his argument in para 2? Mr. P.P. Rao, the learned senior counsel appearing for the petitioner, has submitted that if termination has in fact been effected by way of punishment, the real purpose of the order, not the outer form of it, is required to be looked into by piercing the veil. Please pause, Lordship. This exact argument has been taken by the appellants. Exact. By the learned senior counsel. He has submitted that if on the score of misconduct, the service is terminated without holding any departmental proceeding and giving the petitioner a chance of showing cause, the order of ex parte termination of service on the ground of misconduct is illegal and void. Even in the case of service, temporary service, the provisions of Article 311 of the Constitution is applicable. In support of the contention, reference has been made to the decision of the court in Jarnail Singh versus State of Punjab. Lordship, that's a 1986 judgment. It, however, appears to us that no discriminatory treatment has been meted out to the petitioner as was done to the employee concerned in the said decision. It appears that the service of the petitioner was found unsatisfactory for the reasons indicated herein above. Since the petitioner was holding a temporary service and was on probation, the order of termination simpliciter has been passed without attracting any stigma against him, as the service records were found unsatisfactory. Lordship, we have also placed all that before the learned single judge. That all the service, each one's individual file, which was considered. So even with regard to this argument, it is not as if there has not been application of mind based on the service records. As the service records were found unsatisfactory, the termination order cannot be held arbitrary and capricious. In the aforesaid facts, we do not think that in reality an order of punishment has been passed against the petitioner in the cloak or pretense of termination simpliciter without holding a departmental proceeding, thereby violating Article 311. We therefore find no merit in the petition. Then, Lordship, we are 1996, 5 SCC, 89, 2-judge bench, KV Krishna Mani versus Lalit Kala Academy. Lordship, para 2. Lordship, the High Court, appellant was appointed initially on an ad hoc basis, and therefore with a view to regularize his services, he was put on probation. I am on the 4th line between placentum A and B. During probation, his services having been found to be not satisfactory, were terminated by proceedings dated so-and-so. The appellant came to challenge the same by filing the writ, which was dismissed by the High Court, thus this appeal by special leave. It is contended by the appellant that since the averments made in the counter would constitute foundation, the Lordship, it is contended by the appellant that since the averments made in the counter would constitute foundation for dismissal for misconduct, an inquiry in this behalf was required to be made. On the other hand, it is contended by the respondent that during the probation, the appellant did not acquire any right to the post. If on being found suitable, he was regularized, only then he would have acquired the right to continue in the post. During probation, it was found that his services were not satisfactory and reasons were given in support thereof. Thus, they do not constitute foundation but motive to terminate the services. We find force in the contention of the respondent. They have explained that the driving of the staff car was not satisfactory and that therefore they have terminated the services of the appellant during probation. The very object of the probation is to test the suitability, and if the appointing authority finds that the candidate is not suitable, it certainly has the power to terminate the services of the employee. Under these circumstances, it cannot be held that the reasons mentioned constitute motive, not foundation for termination of service. Therefore, we hold that the High Court has not committed any error of law. Now, Lordship may pass. Let's go back to the second sentence of para 4. It is contended by the appellant that since the averments made in the counter would constitute foundation for dismissal. Now, Lordship, an argument has been placed before Lordship based on the first affidavit of the state, where the word foundation has come. And therefore, it has been argued, since that is the stand, which an argument is made that we have reneged from it and come with a second and more improved affidavit as an additional affidavit. First, on the additional affidavit, it is additional in a few cases. But in the case, for example, of Kunal Das, it is the affidavit in reply, in opposition. It is not an additional affidavit. The stand is identical. Now, in this particular case, relying on the counter, the argument was made that it is the foundation, not the motive. So I have two things to say. That argument, Lordship, has been rejected because the real motive is what they see, what is the inducing factor. Second, Lordship, in one of the judgments I showed yesterday, where even there was a foundation, the Honorable Court said that being the foundation, temporary employee does not have a right. So I think, Lordship, the continuation of judgments are, there is no quarrel with the settled legal position with regard to 3112. There's no quarrel with that. But what is critical is not a blind application of that principle without looking at what is the material, the inducing factor for arriving at the satisfaction of discharge of a probationer or temporary employee. That is the critical factor. Linked to that is the argument that there cannot be a straight jacket application of or acceptance of an argument of principles of natural justice. There are exceptions to it, and again, coming back to what will be the outcome of it, whether it would be an exercise of futility, whether it would be an empty formality, this would be there. Now, the principles of law lordship will obviously remain static. The question is the applicability of those principles in a given set of facts. And I am bringing before lordship for your consideration, lordship and ladyship's consideration, that all of the judgments are pointing to where the exceptions have been applied in what may broadly be said for temporary or probationers. And the arguments that are professed are the arguments that have been taken in similar, if not identical cases. And these are the very judgments also, lordship, and arguments, respectfully, lordship, that have been placed before the learned single judge and considered. Of course, lordship, we have a few additional judgments beyond what was placed for the learned single judge. Next, lordship. Lordship.
What, according to you, would you say would be the, in your case, would be the foundation, and what are the motive?
No, lordship, it is the motive.
Hmm?
It's the motive.
Motive.
The inducive. Absolutely, lordship, no question about it. It is the inducing factor, lordship. Objective material for the subjective satisfaction. Non-stigmatic, lordship, we have shown that also. We have gone to another level to show even an order that may be considered a stigma, Naresh, FIR, etc. What they can claim for is consideration of removal of that word, which was allowed in Naresh. And that lordship would fall onto, and because I'm here to assist the court. And lordship, I would say that there are 3 particular cases in which the order is more detailed. In their balance, 50 odd cases, lordship, the orders are identical as I read out, lordship. Just simpliciter discharge under the rules. So the reason I placed Naresh was to even point out, lordship, 2 arguments. The first being what I have already said, lordship, that what was the final relief that was given. And the second, lordship, I have taken the argument of Article 14, both in the positive sense, similarly placed being treated similarly, and also the rejection of the argument of negative equality. Lordship, the next judgment, lordship, I will take a little time. There are many things because this judgment also deals with, the CG deals with 56G. So, lordship, this judgment also considers the argument of 56G. That was something that had come from the float from the bench, lordship, had asked this query. Now, this is, lordship, this is the integrity question came against a judicial officer on probation. That's why it is, lordship, 2005, 1 SCC 132, 2 judge, lordship, Registrar High Court of Gujarat versus CG Sharma. कौन सा? एक होगा, एक है ना, मैंने रखा है। ढूंढ के पागल मत हो, ये रहा। One judgment of mine, lordship, I had kept separate and I had kept it in continuation in my file. So my 2 colleagues have been distracted all this while because they were in panic when I'll come to the judgment. Where is that judgment? Then, lordship, we come to the 2 rules. Even if I'm unreasonable and I shout, since we've spoken about loud voices, they will follow rule 1, boss is always right. If they disagree with it, they'll go to rule 2, which says return back to rule 1. Boss is always right. So, lordship, Justice Lakshmanan, lordship, Justice Lakshmanan also has written that beautiful judgment on BSNL, which set the test of goods and other things. So, a lot of judgments have come in that period, right? Lordship Justice Lakshmanan. Para 2, lordship. Lordship, I just pointed out the fact that it is basically, he was the respondent, lordship, he was a judicial officer. Both these appeals raised common question of law about the interpretation of the provisions of sub-rule 4 of Rule 5 of the Gujarat Judicial Service Recruitment Rules 1961 regarding the power of government to extend the period of probation. Hence, both these appeals have been heard together and are being disposed by a common judgment. Mr. C.G. Sharma, the respondent in so-and-so, was appointed as Civil Judge Junior Division and Judicial Magistrate First Class on probation for a period of 2 years, vide Government Notification 91. He joined the duties by the order dated 94. The respondent's services were terminated with immediate effect on account of unsuitability for the post held by him upon recommendations of the High Court. 3 years later, Lordship, the said order was challenged in so-and-so on various grounds, more particularly on the ground that 2 years period of probation having expired, the respondent must be deemed to have been confirmed on the post of Civil Judge Junior Division, and therefore respondent's services could not have been terminated without holding a departmental inquiry. The respondent has also invoked the principles of natural justice by contending that opportunity of hearing should have been afforded to him before terminating his services. It was also contended before the learned single judge that the respondent had tried to the best of his capacity to dispose of the cases, and that many others who had no disposal as per the norms were confirmed in the post, but because of the pick and choose approach, the respondent's services came to be terminated. So, Lordship, this is important because pick and choose has also been used as an argument. Lordship may just note that the single judge disallowed it, the DB overturned it, and then, Lordship, we can come to para 10 पे आ जाए 26 10 para 10. In the result, division bench allowed the appeal filed by the respondent Mr. C.G. Sharma and set aside the order passed by the learned single judge by holding that the respondent shall be entitled to all consequential benefits, and if the termination order had never been passed, subject to the adjustment of emoluments drawn by him as an employee of the High Court. Aggrieved by the above judgment and final order, the Registrar of the High Court of Gujarat and the State of Gujarat preferred the SLP Lordship. Para 15. When the hearing of the case was halfway, Lordship may just note in para 12, at that time, learned senior counsel Mr. S. Nageshwar Rao had argued for the court. When the hearing of the case was halfway through, we felt that we should summon the original records from the High Court, namely the ACRs and the vigilance reports, so that the overall performance of the respondent can be analyzed and a decision could be taken. Accordingly, we summoned the records and the same was placed before us and we perused the same, para 15. Same Lordship, all the service records and files pertaining to every one of the appellant was sought by the learning single judge, and for several weeks it was kept available for reference in the court. Lordship may come to para 26. Lordship may just see on para 23 is the probation rule. Just to mark it, Lordship, in which Rule 5.4b clearly is said, Rule 5.4 says that he may be confirmed if, and B says his work is found to be satisfactory. In para 23, I'm just, if Lordship wants the reference of the rule, is there. Para 26. A large number of authorities were cited before us by both the parties. However, it is not necessary to go into the details of all those cases for the simple reason that sub-rule 4 of Rule 5 of the rules is in pari materia with the rule which was under consideration in the case of State of Maharashtra versus Virappa Saboji. And we find that even if the period of 2 years expires and the probationer is allowed to continue after a period of 2 years, automatic confirmation cannot be claimed as a matter of right, because in terms of the rules, work has to be satisfactory, which is a prerequisite or precondition for confirmation, and therefore even if the probationer is allowed to continue beyond the period of 2 years, as mentioned in the rule, there is no question of deemed confirmation. The language of the rule itself excludes any chance of giving deemed or automatic confirmation, because the confirmation is to be ordered if there is a vacancy and if the work is found to be satisfactory. There is no question of confirmation, and therefore deemed confirmation in the light of the language of the rule is ruled out. We are therefore of the opinion that the argument advanced by the learned counsel for the respondent on this aspect has no merits and leg to stand on. Then Lordship may just come to the third last line of the para, above placetum G. We are therefore of the opinion there is no question of automatic or deemed confirmation as contended by the learned counsel. We therefore answer this issue in the negative against the respondent. Lordship, I have already shown the judgment of Justice Chandrachud Durgabai in which he has used the term condition precedent in terms of the confirmation. Para 28. 31. Okay. Lordship, para 30. The argument of the learned senior counsel for the respondent that there is no finding on the fact either by the vigilance or any unit judge that would cast any doubt regarding the integrity, and nothing has been placed on record by the authority before any of the courts to even remotely suggest that the respondent had indulged in any practice that would cast doubts about his integrity. Since the learned single judge and the learned judges of the division bench had not adverted to this fact, we, in order to see the record by ourselves and in order to shorten the litigation, summoned the original records and perused the same. Para 31. We have closely perused the confidential register of the respondent, and it contains series of adverse entries, and it is abundantly clear that the respondent was not having good reputation as judicial officer and his service was far from satisfactory. The district judge concerned, in view of his unsatisfactory performance and questionable integrity, have also recommended for extension of probation from time to time, and ultimately the district judge was of the opinion that no further extension of probation was called for. We have also produced the original correspondence in connection with the probation of the respondent. It can be seen from the above records that the vigilance sense of the High Court had also investigated some matters regarding his integrity. The district judge was of the opinion that though there would be no proof about integrity, Lordship, this is very important, it's an opinion, subjective. That is the argument, the objective material and the subjective satisfaction, Lordship. The district judge was of the opinion that there would be no proof about integrity, but it is a fact that his integrity was doubtful. So it is a fact that his integrity was doubtful, and the representations made by the officer were also filed on many occasions. The representations made by the respondent in regard to the communication of adverse remarks was ordered to be filed before the Chief Justice and other portfolio judges. Now 34, Lordship may mark. This is very important. What are the words used? It is useful to reproduce the remarks made by Mr. Justice so-and-so while considering the note put up by the office on 8/8/94. The remarks read as under. Now, Lordship, I want to read the remarks because when the argument of stigmatic and stigma is used, let us see what was the threshold at which, what kind of words are used, what is there, and yet the Honorable Supreme Court has not held it to be stigmatic or given the benefit of 3-1. Lordship, that paragraph makes very interesting read. As per the office note at points number so-and-so, the status of the reports of the DJ against Mr. C.G. Sharma contain the following remarks. Not industrious, less diligent, below average, inadequate disposals. His conduct was suspicious and he is a dull judge. Complete judicial aloofness is lacking. No clarity of thought and expression. Lordship, respectfully, it really can't be worse than this. Yeah, Lordship, this is a judicial officer. Para 36. Excuse me, Lordship. Decision was taken at the chamber meeting of 94, which is reproduced as under. Having regard to the fact that the overall performance of Mr. C.J. Sharma, Civil Judge, Junior Division and Judicial Magistrate, First Class, Dabhoi, is not at all satisfactory, it was decided that his promotion be terminated on the ground of unsuitability for the post he holds, and government may be moved to pass necessary orders in the matter with immediate effect. It was further decided that since extended period of probation of Mr. C.G. Sharma is over on so-and-so, it will stand extended till government issue orders terminating his probation. So now, Lordship, the probation stands extended. Thus, it can be seen that the respondent is not industrious, less diligent, below average, and inadequate disposals, and that the conduct was suspicious and complete aloofness is lacking, and no clarity of thought and expression, poor in civil work and fair in criminal work, and average in diligence. In our opinion, such an officer should not be allowed to continue in service in public interest. That's the critical words, Lordship. And in interest of judicial administration. The first thing, Lordship, in this judgment, Lordship, I have noted public interest. The second thing they have said is judicial administration. Paramount is public interest. Paramount. And that's why I read those two paragraphs, Lordship, on public interest. Next page, Lordship, may come to 39. Para 39.
In fact, before coming to court today, where this second half, we were thinking, both of us, while we are hearing this group matter, the disposals are coming down. It shows that we are unable to force a summing up from the councils or senior council arguing here, and therefore we are less industrious.
Her Lordship, per contra, that Lordship is so patiently hearing so many counsels that is over industrious. And Lordship on the other side, disposals, unfortunately, yes, Lordship. But what Lordship may be able to say is that these are 50 cases. So Lordship may in one go say that 50 were disposed of in final hearing. Of course, Lordship, certainly nothing about fairness. I think Lordship. I got it. Thank you. So, para 39. In our opinion, judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. It is meant to ensure that the delinquent receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in view of the court or the tribunal. When the conclusion reached by the authority is based on evidence, the tribunal is devoid of power to reappreciate the evidence and would come to its own conclusion on proving the charge. The perusal of the entire record, including the record summoned from the Gujarat High Court, would only go to show that the order of termination was passed by the High Court on the administrative side after examining all aspects, and his overall performance was found not satisfactory. It is also seen from the file that unit judge in charge of Mehsana district, where the respondent was working as a civil judge at Mehsana, and unit judge of Vadodara, as also the Chief Justice, recommended that the probation should not be extended. The recommendations were considered by the standing committee and also referred to the full court. An affidavit has been filed by the registrar on so-and-so, and the High Court has not referred to the said affidavit. In the affidavit, the registrar emphasized that the performance and extension of the basis of the work on overall assessment does not indicate any room for confirmation of the probation period as judicial officer. However, the division bench picked up one aspect of assessment and allowed the appeal. As rightly pointed out by Mr. Ellen Now, learned senior counsel appearing for the registrar of the High Court and State of Gujarat, that the division bench applied the concept of equality as envisaged in articles of the Constitution in a negative manner. In our opinion, Article 14 cannot be extended to legalize illegal orders that others have wrongly got the benefit of the orders. A wrong order cannot be the foundation for claiming equality. It has also been seen from further affidavit filed on behalf of the Registrar of the High Court of Gujarat that on receiving instructions from the advocate on record, it was proposed to reconsider the matter on the administrative side. The matter was placed before the Standing Committee for reconsideration, further consideration, with the office note dated so-and-so. On further study of the relevant file of the respondent, the Standing Committee was of the opinion that the decision of the full court on the administrative side, proposing to terminate the services, was taken in the interest of judicial administration of the state and was bona fide. Para 41. So, Lordship, negative equality has also been covered in this judgment. And I've already referred that this was an argument professed towards the approvers.
Was comparing himself with his colleagues who were confirmed.
Now, Lordship, he was comparing himself with his confirmed colleagues. That was rejected. Para 41. Mr. Colin Gonsalves, learned senior counsel appearing for the respondent, submitted that the, may I read, Lordship? That the termination order is void inasmuch as the order of termination would be punitive and would also amount to a stigmatic order. He, of course, Lordship, has argued about 311 and integrity, all that. Let's come to para 43, Lordship. But the facts and circumstances in the hand are entirely different, and the administrative side of the High Court and the full court was right in taking decision to terminate the services of the respondent, rightly so, on the basis of the records placed before them. We are also satisfied after perusing the confidential reports and other relevant vigilance files, etc., that the respondent is not entitled to continue as a judicial officer, The order of termination is a termination simpliciter and not punitive in nature, and therefore no opportunity needs to be given to the respondent therein. Since the overall performance of the respondent was found to be unsatisfactory by the High Court during the period of probation, it was decided by the High Court that the services of the respondent during the period of probation of the respondent be terminated because of his unsuitability to the post. In this view, the order of termination simpliciter cannot be said to be violative of Article 14, 16, 311 of the Constitution. The law on the point is crystallized and the probationer remains a probationer unless he has been confirmed on the basis of work evaluation. Under the relevant rules under which the respondent was appointed as a civil judge, there is no provision for automatic or deemed confirmation and or deemed appointment on regular establishment or post. And in view of the matter, the contentions of the respondent that the respondent's services were deemed to have been continued on the expiry of the probation period are misconceived. Lordship may just note Wasim Beg is again quoted. We have read about it earlier, Lordship. Now, Lordship may come to para 46. Lordship may just note in para 43 what I was professing was, Lordship, that no opportunity is to be given and on the basis of the records. Everywhere, Lordship, in the facts and circumstances, the 3-4 motivating factors before considering the arguments of one who has approached the court challenging that order of discharge or reversion or termination is, Lordship, beyond the status, temporary, permanent, is what is the material on which you have arrived and whether that material has been considered in its true import to arrive at the satisfaction, objective or subjective satisfaction, and more importantly, Lordship, in public interest. The line of judgments and precedents in all of my compilation that I place for Lordship's consideration is consisted that one with a tainted hand at whatever stage, point of entry or beyond, or on whom there is a taint, is disentitled to claim being in a public office as a matter of right. And Lordship, the 311 argument I've already dealt with, that yes, that law exists, but it applies in the fact of the case and it cannot be blindly applied. Lordship may come to para 46. Lordship, they are relying on the case of UP versus Bihari Lal. The employee was found to be of a bad category, compulsorily retired for not showing improvement despite adverse remarks for several years. So this is a case of Lordship 56J. I just want to deal with it for that reason. The High Court set aside the compulsory retirement and the employee was reinstated on the same day. Appeal was filed by the state and allowed. In para 4 of the judgment, this court held as under. It is now settled law that the entire service record should be considered before taking a decision to compulsorily retire a government servant exercising the power under Rule 56J of the Fundamental Rules. It is not necessary that the adverse remarks should be communicated or every remark which may sometimes be categorized as adverse be communicated. If on an overall assessment of the record, the authority would reach a decision that the government servant should be compulsorily retired in public interest. In an appropriate case, there may not be tangible material, but the reputation built around him could be such that his further continuation would imperil the efficiency of the public service and would breed indiscipline among other public servants. Therefore, the government could legitimately exercise their power to compulsorily retire a government servant. The court has to see whether before the exercise of the power, the authority has taken into consideration the overall record, including some of the adverse remarks, though for technical reasons might be expunged on appeal or revision. What is needed to be looked into is the bona fide decision taken in public interest to augment the efficiency of the public service. In absence of any malafide exercise of power or arbitrary exercise of power, a possible different conclusion would not be a ground for interference by the court in exercise of its power of judicial review. Lordship, I can't add anything to what Lordships have written here. And this Lordship is someone who's confirmed.
Para 47. Lordship, and I have not added anything in an argument because everything that I could have said is in para 46, Lordship, quoting Bihari Lal. In our opinion, what is to be considered in such matters is the examination of the overall entries of the officer concerned and not the entry here and there. It may well be in some cases that in spite of satisfactory performance, still the authority may desire to not extend the probation of an employee, again, Lordship, in public interest. As the opinion of the said authority, the post has to be manned by a more efficient and dynamic person. There is no denying the fact that in all organizations, there is a great deal of deadwood, and more so in government and judicial appointments, which has to be replaced in public interest. Therefore, as pointed out by many courts in India and by this court, it is purely a matter of subjective satisfaction of the High Court. In such a case, the record so considered would naturally include the entries in the confidential reports, character rolls, vigilance reports, both favorably and adverse. There cannot be any justification for interference in such cases. And to Lordship close that paragraph here, is that the underlying factor consistently is public interest. And one has to ask myself, when Lordship yesterday I also placed before Lordship's consideration, where a writ of mandamus could be issued, what would be the limits to that, if I may use that word, Lordship. Primarily, what are the judicial considerations before a mandamus is considered? I ask myself, Lordship, how can their returning back to service be a message that public interest is being served? It certainly would amount to serving their personal interest. There's no doubt about it, because that is their claim on a personal side. But Lordship, can there be faith in the administration with such a heavy taint? And Lordship, all of them are under trial. None have been discharged. In fairness, Lordship, just for an point, it is not that the cognizance order has been challenged. The matter of, in a related case, but of the same FIR has reached the Supreme Court. There is no interference. In such a circumstance, would it amount to serving public interest? And I'll take a second argument, Lordship. What option does a state have? Is it not obligated as part of its constitutional duty? I'm not on rights, I'm on duties. To preserve not just the integrity, but the efficiency of the service and ensure the trust of the public in the occupiers of that office. So our decision, Lordship, respectfully, is that the decision is bona fide. There is no arbitrary exercise of power. There is no pick and choose. Was there material? Yes. Was it on the overall assessment of the material? Yes, Lordship. That's why the word used is a detailed and thorough investigation. I have shown, Lordship, CBI reports again. Some material must be there. It cannot be arbitrary, which it is not. And Lordship, consistently the courts, the settled law is all of it. And there cannot be, and I'm saying it absolutely, Lordship, to assist this court, any quarrel with any of the principles of Tulsi Ram Patel or Shamsher Singh. The principles are evergreen. But can they be applied in such a fact when other cases, the Honorable Court has not accepted the argument based on the material before it and based on the fact that there was no negative intent or malafide intent of the authority. It was in larger public interest. The purpose of probation, everything, Lordship, has been served. We've argued all that, Lordship. Lordship, next is a judgment, Lordship, of this Honorable Court. Was related to DKB, sir? Lordship, we were in the morning just considering that this is by Justice T.S. Mishra, who was Chief Justice. It's long back in 1984. You're just curious whether. Oh, okay. So I stand, my learned colleague has just added to my knowledge. So, Lordship, this is Shekhar Roy versus Union of India. Para 2, Lordship. This is very interesting. The period of temporary employment was 6 years.
And 6 years is very long, Lordship. The petitioner was appointed in 1970 on a temporary basis, vide annexure 2 to the petition. After about 6 years, the services of the petitioner were terminated. He filed a representation against the said order, which was rejected by the Director General, Post and Telegraph, New Delhi. And the petitioner was informed vide so and so. He made a representation to the Minister of Communication, but to no avail. Hence, he filed the instant petition, which has been opposed by the Union India. And an affidavit in opposition has been filed by the Senior Superintendent of Post Offices, wherein it has been averred that the services of the petitioner had been terminated in terms of Rule 5.2 of the rules, inasmuch as his service was not found to be satisfactory by the department. Further, it has been averred that as the services of the petitioner were terminated not by way of punishment and without attaching any stigma on him, the order of termination was not violative of the provisions of Article 3112 of the Constitution, nor was it violative of Article 14 and 16 as alleged by the petitioner. The petitioner has also alleged in his petition that he had served for 6 years and he had become quasi-permanent employee. Hence, his service could not be terminated under Rule 5. This fact has also been repudiated in the affidavit in opposition by pointing out that the petitioner was never declared quasi-permanent. The petitioner has filed his affidavit in reply, reiterating his averments made in the petition. Now, Lordship, this is a new argument that somewhere between probation and between confirmation is a quasi-right by sheer efflux of time. That is the crux of the argument. Doesn't apply in our case, but look at the length of the service, Lordship. Para 6, Lordship, at page 37. It was next urged on behalf of the petitioner that the impugned order was violative of Article 3112 of the Constitution. The submission was, though the order did not contain any statement wherefrom it could be inferred that a stigma was imposed on the petitioner, the record would show that the order was passed with a view to penalize him. In our opinion, this contention is equally meritorious. Now, Lordship, this is the identical argument. I am merely showing this argument has come in its identical form. What has the Honorable Court held? It was not disputed that the services of a temporary employee could be terminated by giving him 1 month's notice or 1 month's salary in lieu of the notice. Nor was it urged that for the purpose of putting an end to the services of a temporary employee, a departmental proceeding should invariably be taken. The contention was that if on the scrutiny of record, it is found that the services of the temporary employee were terminated by way of punishment without resorting to departmental proceedings, the order would be invalid. The principle that even temporary government servants are also entitled to the protection of Article 3112 in the same manner as permanent government servants, if the government takes the action against them by meting out any of the 3 punishments, which is dismissal, removal or reduction in rank, it might well be settled. Purushottam Lal Dhingra. Then, Lordship, that is reproduced, Lordship. We can, Lordship, come now to para 11 at page 38. Now testing the facts. Now testing the facts and circumstances of the instant case in the light of the principle above noted, we find that the allegations of malafide and arbitrariness have not been substantiated by the petitioner. Exactly what I was arguing, Lordship. There is no malafide or arbitrariness. A bare allegation unsupported by any evidence would not make the order arbitrary or malafide, nor would be sufficient to conclude that it was passed with a view to impose stigma or inflict any penalty on the petitioner. No specific allegation of malice has been made against the authority who passed the impugned order of termination of service. The order in question does not impose any penalty. It has been passed in accordance with the provisions of Rule 5 of the rules, which lays down that the services of a temporary government servant who is not in quasi-permanent service shall be liable to termination at any time by a notice of writing given either by the government servant to the appointing authority or by the appointing authority to the government servant. The period of such notice shall be 1 month. Lordship may go to the 4th last line on that page. Of that, it is an order simpliciter. Has Lordship got that? It is an order simpliciter. The question of scrutinizing the official records does not in the instant case arise because the petitioner has not made out any case before us warranting the scrutiny of records. Lordship may come to the next paragraph, para 15 at 39. The learned counsel for the petitioner, however, submitted that a criminal case has been launched against the petitioner. Hence, the order was mala fide and arbitrary and was by way of punishment. Now, Lordship, this argument also has been placed for consideration by the appellants before Lordship. No doubt, the petitioner was prosecuted in a criminal court, and during the pendency of that trial, his services were terminated under the provisions of Rule 9 of the rule. It is open to the appointing authority to terminate the service of a temporary employee during the pendency of criminal proceedings. If the service of a temporary employee during the pendency of criminal proceedings, if the appointing authority is satisfied that the temporary employee is not suitable to hold the post. There is no rule that on initiation of a departmental or criminal proceedings, services of a temporary employee cannot be terminated by an order of termination simpliciter. This fits again, Lordship, to our case.
Exactly.
So, Lordship, the argument that there is an FIR, that there is a trial, that there is a charge sheet, there is a trial, the order is stigmatic once you lift the veil of the order, and it's not just a simpliciter discharge. Lordship, that argument has not been accepted by the court. The court has reiterated the power of the government or the appointing authority, as the case may be, to dismiss a temporary or probationer. Lordship, this was dismissed eventually. Lordship, I would now like to deal, what may I call, Lordship, the magnus opus, which comes up for consideration before every court. Parshottam Lal Dhingra and Shamsher. And in fairness, Lordship, as I had mentioned yesterday, there are many Lordship, there are some judgments that everybody relies on. It doesn't matter which side. The appellant or the respondent, or vice versa. Lordship, Parshottam Lal Dhingra, AIR 1958, SC 36. Lordship, just to let Lordship know, I could read it also, Lordship, because this had come in terms of English law and the power of the Crown. That is in Lordship, para 5 onwards. If Lordship so pleases, I'd be happy to read it. I'm just pointing it out, Lordship, para 5. But it is, Lordship may just mark it for consideration later, because this had just flowed in one of the comments from the bench, Lordship. Then, Lordship, para 11 broadly, Lordship, is about employment on probation, what it means. What it means. Lordship may now come to para 26. And 28, Lordship, which is what I'm going to rely on, Lordship. May I, Lordship? The foregoing conclusion, however, does not solve the entire problem, for it has yet to be ascertained as to when an order for termination of service is inflicted as and by way of punishment and when it is not. It has already been said that where a person is appointed substantially to a permanent post in government service, he normally acquires a right to hold the post until, under the rules, he attains the age of superannuation or is compulsorily retired, and in the absence of a contract express or employed or a service rule, he cannot be turned out of the post unless the post itself is abolished or unless he is guilty of misconduct, negligence, inefficiency, or any other disqualification, and appropriate proceedings are taken under the service rules read with Article 3112. Termination of service of such a servant so appointed must per se be a punishment, for it operates as a forfeiture of the servant's rights and brings about a premature end of his employment. Again, where a person is appointed to a temporary post for a fixed term of say 5 years, his service cannot, in the absence of a contract or a service rule, permitting its premature termination be terminated before the expiry of that period unless he has been guilty of some misconduct, negligence, inefficiency, or other disqualifications, and appropriate proceedings are taken under the rules read with Article 3112. Pause for a minute, Lordship. It makes it clear in this that the rules have to be considered. So in the absence of which, this will follow. The premature termination of the service of a servant so appointed will prima facie be dismissal or removal from service by way of punishment, and so within the purview of Article 3112. Further, take the case of a person who, having been appointed temporarily to a post and has been in continuous service for more than 3 years, or has been certified by the appointing authority as fit for employment in a quasi-permanent capacity. Such person under Rule 3 of the 1949 temporary service rules is to be deemed to be in a quasi-permanent service, which under Rule 6 of those rules can be terminated. 1. In the circumstance and in the manner in which the employment of a government servant in a permanent service can be terminated. Or 2. When the appointing authority certifies that a reduction has occurred in the number of posts available for the government servants not in temporary service. Thus, Lordship may mark from here. Thus, when the service of a government servant holding a post temporarily ripens into a quasi-permanent service as defined in the 1949 temporary service rules, he acquires a right to the post although his appointment was initially temporary, and therefore the termination of his employment otherwise than in accordance with Rule 6 of those rules will deprive him of his right to that post which he acquired under the rules, and will prima facie be a punishment and regarded as dismissal or removal from service so as to attract the application of Article 311. Except in the 3 cases just mentioned, a government servant has no right to his post, and the termination of service of a government servant does not, except in those cases, amount to dismissal or removal by way of punishment. Now, very important for us, Lordship. Thus, where a person is appointed to a permanent post in a government service on probation, and the termination of his service during or at the end of the period of probation will not ordinarily and by itself be a punishment. For the government servant so appointed has no right to continue to hold such a post any more than the servant employed on probation by a private employer is entitled to do so. Such a termination does not operate as a forfeiture of any right of the servant to hold the post, for he has no right and obviously cannot be a dismissal, removal, or reduction in rank by way of punishment. Pause, Lordship. Several things become clear here. One, Lordships have held, and being a constitution bench, that one on probation is all similarly placed, whether he is in a private enterprise or a government enterprise. 2, Lordship, what this small passage here reads is that ordinarily and by itself be a punishment. So, Lordship, what is now laid is a threshold of an exception needing to be proved. That means the automatic applicability of 3112 is not the norm. It is an exception, in fact. What is an exception? In a certain set of circumstances. Now, Parshottam Lal Dhingra has been considered in many of the judgments that we have relied upon. And after being there, considered, the principle is not being touched. The principle remains where it is, exalted as it is. But its applicability has been rejected in several cases that would be, if not identical, broadly similar to what the respondent state is arguing or keeping for consideration before Lordship. Now, Lordship may consider going down by about 10 lines, Lordship, where the sentence on the right-hand side, Lordship may note there is the word 1957 rules shortly put, comma.
Please come back again.
Yes, Lordship.
Very difficult to accept it, that this 3112 would be an exception. Please elaborate.
So, Lordship. So, let me, Lordship, why I said, and I'm going to read it again after saying so, Lordship, I chose my words. You have to show real stigma
real prejudice? That's the first threshold. Second, is there mala fide? There's arbitrariness to the act. You have to, and who will show this, Lordship? It is not for the state to answer. It is for the petitioner, or in this case, the appellant, to show that. 3, what is the universe of the material for the government to consider? And that's consistent, Lordship, from 94, whether I take the Krishan Yadav series of judgments, or if I bring it right down to R.S. Dhaba, any one of the judgments, Lordship, it is consistent. What is the material, which is the objective material for the subjective satisfaction of the authority? Now, Lordship, merely because the appointing authority, or the government in this case, is relying on a police investigation, something that is before the learned trial court, and once that is in the knowledge of the government, would the government require to be under a compulsion to adhere to principles of natural justice when the settled law is that there are exceptions to it? And these are probationers. So for a probationer who is similar to a private employee, for him or her to say that 311 must apply, that argument of blanket applicability is not there. Now the argument comes, what is stigma? And the argument of foundation and motive. I have shown judgments where even when it is the foundation, that has been treated as motive, which I've done today, Lordship. I've shown it yesterday too. As far as the government is concerned, it is the motive and the inducing factor. So, Lordship, that's why that sentence, I'll read it now again. And I'm grateful for Lordship to ask me to do that. Thus, from there, Lordship, where a person is appointed to a permanent post in a government service on probation. So first, a probationer. The termination of his service during or at the end of the period of probation will not, and Lordship may mark, ordinarily. That means it is not the norm. Every word has to be read, Lordship. Ordinarily, next, Lordship, and by itself, which means it is not automatic. Just because you have terminated it, it is not automatic applicability of 3112. So, will not ordinarily and by itself be a punishment. For the government servant, so appointment, now what is his status? Has no right to continue to hold such a post, which is the law on the probationer, any more than a servant employed on probation by a private employer is entitled to do so. Such a termination does not operate as a forfeiture of any right. So therefore, what is it? If you don't have a right, how can the argument of a forfeiture of that right arise? For he has no such right, and obviously cannot be a dismissal, removal, or reduction in rank by way of punishment. So, Lordship, I am harmonizing. Why I brought Purushottam Lal Dhingra at this point is because, Lordship, if I start with this, I have to then build and keep sharing before Lordship the various propositions that have come through the various judgments. I read it here with a purpose, Lordship, that having shown what has been the consistent view in a similar set of circumstances, somewhere almost identical, where this argument has been professed of 311, principles of natural justice, lifting the veil and the order simpliciter being actually a stigmatic order, keeping in view an order which also may be considered stigmatic, as in the case of Naresh, Lordship, FIR is mentioned there, or if I may take CG, Sharma. In all these cases, Purushottam Lal Dhingra has been urged, but the Honorable Court has not accepted it. And this passage, Lordship, why I come to this passage specifically, because it speaks about what is the circumstance and its applicability. So that's why, Lordship, at the end I came here. As I would at the end now, after this, go to Shamsher Singh. The Lordship may just make a note, Lordship, for the facts which will be relevant for this. Lordship may just, for a moment, come back to para 11. If I may now build this argument a little further, in reverse. यहीं से पढ़ देता हूं. Has Lordship got para 11? The appointment of a government servant to a permanent post may be substantive or on probation or on an officiating basis. Lordship may be pleased to come down about 10-12 statements where the sentence starts an appointment to a permanent post on the right hand side, Lordship. An appointment to a permanent post in a government service on probation means, as in the case of a person appointed by a private employer, that the servant so appointed is taken on trial. The period of probation may in some cases be for a fixed period, example 6 months or for 1 year, or it may be expressed simply as on probation without any specification of any period. Such an employment on probation under the ordinary law of master and servant comes to an end if during or at the end of probation the servant so appointed on trial is found unsuitable and his service is terminated by a notice. Now, Lordship may come 14 sentences from the bottom where it starts with the sentence, likewise an appointment to a temporary post. Likewise, an appointment to a temporary post in a government service may be substantive or on probation or an officiating basis. Here also, in the absence of any special stipulation or any specific service rule, the servant so appointed acquires no right to the post, and his service can be terminated at any time, except in one case, namely, when the appointment to a temporary post is for a definite period, which is not applicable, obviously, Lordship, to our case. 28. Now, Lordship, I was reading para 28, and I had then requested Lordship to go about 10 sentences down. Yeah, Lordship, may give me a minute. Lordship, I had said that it's about 10 sentences down where it ends 1957 rules, and I would read from shortly put. Has Lordship got that?
Para 28.
I'm on para 26 only, Lordship.
26.
I had finished reading that part, Lordship, where Lordship had asked me to build on it further.
Yes.
Then about 10-12 lines down, it ends with Rule 13 of 1957 rules, and then it starts with the sentence, words shortly put.
Yes, shortly put.
Yes, dear, I'm so grateful. Shortly put, the principle is that when the servant has a right to a post or to a rank, either under the terms of the contract of employment, express or implied, or under the rules governing the conditions of his service, the termination of the service of such a servant or his reduction to a lower post is by itself and prima facie a punishment. Obviously, Lordship, it will be, if the rules so say. For it operates as a forfeiture of his right. So, Lordship, may just make a note. What is the important thing consistently, whether I read para 11 or 26, is does a probationer have a right to a substantive post? No, Lordship, that is not so. That's what is the absolute clear position. For it operates as a forfeiture of his right to hold the post or that rank and to get the emoluments and other benefits attracted thereto. Now, Lordship may mark, but if the servant has no right to the post, as where he is appointed to a post permanent or temporary, either on probation, Lordship, or on an officiating basis, and whose temporary service has not ripened
into a quasi-permanent service as defined in the temporary service rules, which is absolutely in our case too, the termination of his employed does not deprive him of any right and cannot therefore by itself be a punishment. One test for determining whether the termination of the service of a government servant is by way of punishment is to ascertain whether the servant, but for such termination, had the right to hold the post. The right to hold the post is the determinant. Because if you have a right, the violation of that right has to be protected by the court. Which is what Lordship Article 311 is about. The protection of a right. But you cannot claim a right that does not exist. And hence cannot demand a protection automatically or in the ordinary course of life or business, if I may say, Lordship. If he has a right to the post, as in the three cases herein above mentioned, the termination of his service will by itself be a punishment and he'll be entitled to the protection of 311. So Lordship may again mark, if he had a right to the post, then 311 will come. In other words, and broadly speaking, Article 3112 will apply to those cases where the government servant, had he been employed by a private employer, will be entitled to maintain an action for wrongful dismissal, removal or reduction in wrong. To put it in another way, if the government has by contract, express or implied, or under the rules, the right to terminate the employment at any time, then such termination in the manner provided by the contract or the rules is prima facie and per se not a punishment and does not attract the provisions of Article 311. Now, Lordship, this is exactly what I was, in my choice of words, appropriate or inappropriate, Lordship, seeking to say when I read the earlier part of the paragraph. A right will lead to an infringement. An infringement of a right will lead to consideration under the writ jurisdiction and action, or the protection has to come into force. But the lack of a right cannot lead to the automatic invocation of any provision of the Constitution. In this case, Lordship, we have argued, and that is our stated stand, Lordship, consistently. What is their right? Much less the fundamental right that they seek has been infringed, that they argue or place before this court that's been infringed. They have to establish a right. Now, Lordship, para 28. Now, Lordship, I'm reading 28 because I would like to read 28 as my learned senior colleague, Mr. K.N. Chaudhary, had read it. So for Lordship, let me also read the same paragraph and place before Lordship and see if an alternative understanding of the same paragraph may be considered. The position may therefore be summed up as follows. Any and every termination of service is not a dismissal, removal, or reduction in rank. A termination of service brought out by the exercise of a contractual right is not per se dismissal or removal, as has been held in the court in Satish Chandra Anand versus Union of India. Likewise, the termination of service by compulsory retirement in terms of the specific rule regulating the conditions of service is not tantamount to the infliction of a punishment and does not attract Article 3112, as has been held in the court in Shamlal versus Uttar Pradesh. In either of the two above mentioned cases, the termination of the service did not carry with it penal consequences of loss of pay or allowance under Rule 52 of the Fundamental Rule. Now, Lordship may mark. This is very important, Lordship. It is true that the misconduct, negligence, inefficiency, or other disqualification may be the motive or the inducing factor. So, Lordship, this inducing factor word has been used consistently and it comes from this judgment. I'm reading again, Lordship. It is true that the misconduct, negligence, inefficiency, or any or other disqualification may be the motive or the inducing factor which influences the government to take action under the terms of contract of employment or the specific service rule. Nevertheless, if a right exists, and Lordship, that is the critical differentiator. If a right exists under the contract or the rules to terminate the service, the motive operating on the mind of the government is, as Chief Justice Chagla has said in so and so, wholly irrelevant. In short, if the termination of service is founded on a right flowing from the conduct or the service rules, then prima facie, the termination is not a punishment and carries with it no evil consequences, and so Article 311 is not attracted. That's the part I'm relying on. May I respectfully, Lordship?
We'll look at the next sentence also.
I said, I'm relying on that. I've clearly said it. I'm not right. That is what K.N. Chaudhary sir read, so I thought I will read out the part that I'm relying on.
Okay, no, completion.
I will. Lordship, my friend wants me to, I'll go back to it. And I'm not running away. But even if the government has by contract or under the rules the right to terminate the employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction of life, the government may nevertheless choose to punish the servant. And if termination of service is sought to be founded on misconduct, negligence, inefficiency, or other disqualification, then it is punishment, and the requirements of 311 must be complied with. Now, Lordship, I will take this head on. As we say, let's take the bull by its horns. This, respectfully, according to me, is not the point. It flows from right and the service rules. And it flows when what is paramount, and I've read those paragraphs 44 and 45, public interest. And it is not to be applied in the ordinary course and instantly. So what has to be shown is the infringement of a right, not the desire of the existence of a right. And a probationer has no right. That is the law. The exceptions of Parshottam Lal Dhingra, the applicability would be, Lordship, based, I would say respectfully, have no applicability in the given set facts of this case. Because our order, Lordship, is a simpliciter discharge order for a probationer carrying no stigma, based on materials that are objective for the subjective satisfaction of the state. And as I said yesterday, the state has the obligation and a constitutional duty. So if a right is being brought forth, or if a right is being brought as an argument, the state has a constitutional duty to preserve the integrity of the service and maintain the public interest and public trust in the public office. Oh. Would Lordship? I don't know, it's a change of better. I believe Lordship has a bench.
Yes, you continue for some time.
So, Lordship, I was thinking if I can finish Shamsher Singh, that would close this, and the next would be a separate compilation which I could begin on Monday, but I will be seeking Lordship's indulgence if I could do it on VC on Monday. May I read Shamsher, Lordship? Para 62 and 64. So, Lordship, the proposition that we are relying on and placing for Lordship's consideration is para 64, actually starts at para 62, Lordship, which is the Article 14 exception, Lordship. So 7 judge we know, Lordship. And Lordship may come to para 62, which reiterates the position of a probationer of Parshottam Lal Dhingra. But I'm going to read it, Lordship. I told you. Lordship, my learned friend and colleague from the bar is saying I've also marked 62. And I said 64. That's why I said, Lordship, I said in fairness, we can't quarrel on the principles of law and we all will rely on it. Finally, Lordship, as I had said yesterday, and I don't know if my learned friend was there, I said, Lordship, ultimately what comes is in the given set of facts of the case. May I, Lordship, read? It's only 3 paragraphs and I'm grateful Lordship is permitting me to complete this. 62. The position of a probationer was considered by this court in Parshottam Lal Dhingra versus Union of India. Chief Justice Das, speaking for the court, said that when a person is appointed to a permanent post in government service on probation, the termination of his service during or at the end of the period of probation will not ordinarily and by itself be a punishment, because the government servant so appointed has no right to continue to hold such a post any more than a servant employed on probation by a private employer is entitled to do so. Such a termination does not operate as forfeiture of any right of a servant to hold the post, for he has no right. Obviously, such a termination cannot be a dismissal, removal, or reduction in rank by way of a punishment. I've read that, Lordship. I'm merely pointing out it's relied upon in this. Now, Lordship, 63. No abstract proposition can be laid down that where the services of a probationer are terminated without saying anything more in the order of termination than that the services are terminated, it can, please mark, Lordship, never amount to a punishment in the facts and circumstances of the case. If a probationer is discharged on the ground of misconduct or inefficiency, or for a similar reason, without a proper inquiry, and without his getting a reasonable opportunity of showing cause against his discharge, it may be in a given case amount to removal from service within the meaning of Article 3112. Para 64, Lordship. Before a probationer is confirmed, may I, Lordship?
Yes.
Before a probationer is confirmed, the authority is under an obligation to consider whether the work of the probationer is satisfactory or whether he is suitable for the post. In the absence of any rules governing a probationer in this respect, the authority may come to the conclusion that on account of inadequacy for the job or for any temperamental or other object not involving moral turpitude, the probationer is unsuitable for the job and hence must be discharged. No punishment is involved in this. Would you like me to read the rest? I'll read it, Lordship. The authority may in some cases be of the view that the conduct of the probationer may result in dismissal or removal on an inquiry. But in those cases, the authority may not hold an inquiry and may simply discharge the probationer with a view to giving him a chance to make good in other walks of life without a stigma at the time of termination of probation. Now, Lordship, just pausing for a minute. I ask myself, where is that stigma in the order? It's a simpliciter. And the argument of lift the veil, I've dealt with separately. May I continue, Lordship? If, on the other hand, the probationer is faced with an inquiry on charges of misconduct or inefficiency or corruption, and if his services are terminated without following the provisions of Article 3112, he can claim protection. In following the provision, he can claim protection. In Gopi Kishore Prasad versus Union of India, it was said that if the government proceeded against a probationer in the direct way without casting any aspersion on his honesty or competence, his discharge would not have the effect of removal by way of punishment. Instead of taking the easy course, the government chose the more difficult one of starting proceedings against him and branding him as a dishonest and incompetent officer. Now, Lordship may just come back again to the middle of the page. If, on the other hand, the probationer is faced with an inquiry. So, Lordship, here, of course, the inquiry has to be a departmental inquiry. I think two arguments are being made. And respectfully, Lordship, I would like to clarify that. Lordship, the question is the material that is available to the government on the basis of the police investigation, or I will now use the word police inquiry. I'm using the word just so that I can use the word inquiry. Would that amount to being compared with the use of the term inquiry, which is under service law, the procedure of issuing a show cause notice, seeking a response, appointing an inquiry officer, having the departmental proceedings, framing of charges, response, and thereafter? Respectfully, no. I think, and I will use this now for two arguments, Lordship. The use of the word foundation, foundational facts would not automatically arrive at a conclusion that this is the foundation in terms of the foundation and motive. Those judgments have done so, Lordship. My affidavit also I pointed out, and in CG Sharma pointed out that that has been considered and rejected. The use of the term is not important. It is the intent in terms of the foundational facts. Even, Lordship, in the three-judge bench, which was of Justice of the Honorable Supreme Court by Justice Bobde, Justice Gawai, and Justice Suryakant, I had pointed out and highlighted the word foundation. It was treated as motive. So I think respectfully, Lordship, it's an argument that I would say, without any offense to the other side, an argument of clutching at straws and picking a word to somehow overcome the fact that they have no right as probationers. And the argument of having a right and its infringement is not being established or has not been established. What they are seeking, Lordship, respectfully, is the protection or the indulgence of the Honorable Court of invoking a protection without establishing the presence of a right. Which is why, Lordship, I have mindfully taken Lordships through the law on probationer to establish conclusively that a probationer has no right. Again, here they make the comparison of the public servant with a private servant. Once they cross that threshold, Lordship, the next threshold that needs to be called, do I have a right or not as a probationer? They have to cross that. Second, is there real prejudice? 3, what is the inducing factor which operates on the mind of the government for satisfaction in taking the decision? And finally, Lordship, can they claim that Article 14 or principles of natural justice would apply to their case? The line of judgments that we have placed before Lordship, respectfully, to close this argument of today, point towards the fact that it would not be applicable in their given set of facts. And Lordship, to close my argument of today with one sentence, the inquiry which is in para 64 is not a substitute or cannot be intermixed with the police inquiry or the investigation. That's the point, which is why para 64
I did, and I'm so grateful Lordship permitted me to finish this line of judgments today, Lordship.
This, according to you, is what?
That
This
is my
enquiry-
reading of it.
No, this inquiry, according to you, is what?
Departmental inquiry.
No.
100% Lordship, that's my argument. Because Lordship, there is no consideration of a police report here.
No, this is the inquiry on the basis of which they got the material. That's not the department.
Removal on an inquiry.
Yes. 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 In other words.
Lordship, yes, inquiry on the charges of misconduct. So Lordship, why I'm saying the three words that become relevant to bolster my argument, Lordship, is inquiry on the charges of misconduct. So Lordship, with regard that's what for today, Lordship. I'm grateful for Lordship's consideration. Both the wicks helped me through today's argument. Lordship, I'm only requesting for the VC link on Monday. I will,
No,
of course.
Monday the bench would not be available.
Okay, Lordship.
11th.
11th.
Yes.
Lordship, 10th,
Monday.
which is Tuesday.
11th you're going. Right?
Monday.
11th you're going. Tuesday.
11th is 11th, Tuesday.
You're going, right?
Oh. 11th is Wednesday, I thought. It's Wednesday. You correct.
Wednesday. 10th you're
After
going.
11th, I'm going on. Then I'll have to do it 12th. London.
He said the precursor to the department. I said, no, no, the material. It's 164 says. Yeah, so it says he for the other anyway. But he's saying that what is the departmental inquiry? He says precursor to the, like you say, we will go to that.
There's every likelihood of disruption of bench on Monday and Tuesday.
Then, Lordship, if in case the bench is there, wonderful, Lordship. 11th, I will be in transit, Lordship. I'll do it from where I go on 12th, Lordship.
12th. Okay.
The 11th, Lordship, I'll be in transit, so I will not be able to assist Lordship on that day.
Okay.
And Lordship, if I may seek Lordship's indulgence, if possible, on that day, some additional time could be given, Lordship. I could try and close the arguments. Otherwise, I'm there, Lordship.
No, we'll have to close it because
I understand, Lordship, there is a timeline. That's why I'm also aware, Lordship. I will also, Lordship, in this period, work to see that perhaps I may reduce reading of some of the paragraphs, Lordship, and indicate that these are the paragraphs, Lordship, and these are the paragraphs I wish to read. It will just save some time.
Okay. Mr. Arnab Chaudhary, Senior Counsel, along with Mr. S. Das, Mr. Prasad, Ms. B. Chaudhary, and others who are there, please give their names, we'll record it. Present for the present, all the applicants are represented.
Yeah, that's one.
The submissions of Mr. N. Kohli, Senior Counsel, there's all these names, so and so. We may see inconclusive. List as a part of the matter on 12/6/2025.
So grateful, Lordship. Grateful, Lordship.
Item 1, IA Civil 123. IA Civil 123/2025.
the appeal is allowed, the award stands reduced to rupees 1,58,497 with interest from the date of claim petition till realization to be paid within a period of 30 days from the date of the order. Mr. Krishnatha, you made a request yesterday for some
Sorry, Lordship.
some cases, but by then the order was already dictated.
Yes.
We could not make any further adjustments after that.
Sorry.
No, it's okay, but
The judgment
I-
passed in our case.
yes, yes.
Oh, sir, that's why we did not.
No, that is there is a bench with Itanagar.
Oh, sorry, Lordship. Lordship, yes, I apologize for that.
No, it's okay. We can't help it. But since the request came to me, I told you.
Yes, Lordship.
It-
Otherwise, Lordship, there is a judgment that the multiplier is applicable, Lordship. Multiplier is applicable.
Yeah, I have given the reasons. You
Yes,
you
yes.
check that.
Sure. Okay.
Yes, Mr. Picha.
Yes, my lord. May I, my lord?
Yes.
There has been this IA 123, man.
Yes.
There has been 10 days delay for filing this review petition. But this honorable court, my lord, your lordship has passed the judgment, my lord, on the instruction given by the government advocate, my lord, state government advocate, my lord, page 16, my lord. Of my IA, my lord.
Okay. Delay of how many days?
10 days, my lord.
We issue notice then.
Everyone is appearing, yes, my lord. State is represented.
Okay, all are present.
Yes, my lord. So, my lord, we came to know this order. Well, there is a existing notification which we came to know on 3/5/2025. We have stated our reasons have been stated in para 3, page 7.
No, it's okay, but
No.
we'll issue a notice.
Yes, yes.
Hmm.
Fine.
Yes, ma'am.
Heard Mr. B. Picha, Learned Counsel for the applicant. As well as Ms. P. Sangeeta, Learned Government Advocate, appearing for respondent numbers
1, 2, 3, and 5, Your Lordship.
1, 2, 3, and 5. And Mr.
K. Loya, Lordship. I am representing respondent number 6, 7, 8, and 9, Lordship.
So K. Loya, Learned Counsel.
CGC, Lordship.
Achha, Learned CEC, appearing for respondent number 6 to 9.
7. Yes, Lordship.
Next paragraph.
4 also, my lord, the state council should represent, my lord. It is the
No, Your
chairman.
Lordship, 4 also.
Okay, 4.
ADC dirang, Your Lordship.
Okay. Then you'll be for 1 to 5.
Yeah.
Okay. Issue notice on this interlocutory application. For conducting a delay of 10 days beyond the period of limitation in filing of the connected review petition against the order dated 3/4/2025 passed in WBC 72 AP of 2025. Full stop. How much time you need to respond? 10 days?
Your Lordship, 1 week at least, Your Lordship. 2 weeks, Your Lordship.
2 weeks. Okay. Next paragraph. Affidavit of opposition, if any be filed within 2 weeks. Give a date after 2 weeks, make it returnable on that day.
(20/06).
Okay, 20 June, returnable on 20 June.
My lord, can it be 19 June, my lord? 20, there are so many cases, my.
Today is what?
So then we take it to 24th.
24,
24th, my.
24,
No, 24th, it will be either to, 25th, sorry. 25/6. 20. Okay.
Obligation.
The both the cases same?
Same.
Okay, same order in both the cases. Okay.
Highly obliged, Lordship.
Obliged.
So, Picha, are you saying that the what is the wrong submission?
Well, there is a notification. They have submitted, there was no notification. They have not issued any notification, but there is a notification. My lord, my lord, may I please come to page 18, my lord.
18.
Yes, my lord. They submitted on instruction that there is no notification, but I have, my lord, obtained one notification, my lord. There is an existing notification. My lord, may see page 18 specification of land, my lord. In the boundary description, my lord, my area comes in the first one, my lord. Notified area is along with existing road KM 167.002 to 174.00. My area comes under 173.50, 450.
Okay.
Your Lordship, extra copies may be served, Your Lordship.
Oh, okay. You are already there. Mr. Picha, give her extra copies.
Yes.
Just extra copies within 2 days.